There'll be some kind of broad time limit so that, do you have an idea?
Sir, I will try and conclude by lunchtime. That is what, not longer than lunchtime.
No, but then who else is going to argue?
But after that, Mr. Diwan will come. Mr. Diwan, then there will be Mr. Giri and.
So, but, you have going up to lunch hour for you. Can you cut down?
I will cut it down.
Cut it down by, we would expect you to conclude by 11:15. Half an hour is, unless there is something, because you have already laid your.
But I must tell you a lot of things which I have to cover.
Yeah.
And I must candidly say that. There are. This, I would propose to touch upon the question frame that whether it's colorable legislation.
Yeah.
The effect of the presidential assent. Your lordship has that note, the one pager I gave to you on the last occasion. I set out the structure of submissions. My lord, we just see. So, Lord, what will have to be covered is C, D, E in part 1.
Ms. Luthra, can we have one more of that sheet?
I'm sorry, but let me just see.
No, it's there. Fine.
I'm extremely sorry.
No, it's there.
My lapse, I should have carried extra copies.
No need.
I'm not, if your lordship sees that one pager note, part 1. So C, D, and E is what is to be touched. Question 4.5 is to be dealt with. On part 3, I will make it very short. Part 3 of my notes, I'll make it a short argument, like the one decision and let it fly. If your lordship don't have copies, I do have copies of it. So not that. So it may take a little longer than the 35 minutes your lordship has indicated. And I can assure your lordship, I will one copy.
Brother, would like you to tell us is, what are the cases, how many cases are there?
What are the points involved so that if there are overlapping points, one argument can.
Yes, sir. Not wherever there is an overlapping point.
No, we are asking a bit of housekeeping about.
Housekeeping.
How many petitions?
How many petitions, Lord? I'll give you a lordship. 17 or 18 months.
17, 18. Now, what does each individual petition relate to?
So, Lord, I'll tell you, lordship, there are, I'll make it very clear, Lord. There will be some petitions.
During lunch hour, if a sheet can
be. We'll give you a sheet. Lord, we'll give you a sheet of the petitions and what they relate to. There's a whole chart made.
Amendment acts of 3 states.
Yes, Lord. So, I'll tell your lordship, Lord. Lord, 3 states amendments are there. Some petitions will challenge one or the other amendment. In writ petitions, Civil 24 of 2016, all of them are challenged. All the 3 legislations. 24 of 2016 challenges all 3.
We have the file of 23 with us.
Lord, 23, I'll tell your lordship.
Are you arguing 24?
23, yes, Lord. No, I'm arguing writ petition 24. Writ petition 23 is the petition filed by the Animal Welfare Board of India, where my learned and 2 individuals, Anjali Sharma and Mr. Jaisam, my learned colleague, Ms. Karia, had appeared on the last occasion to point out that there is presidential assent and she wanted the others to start because her view may be somewhat tempered because, as she indicated on the last occasion, she's given a written note which reflects the view that they've taken.
Argument to be mainly on interpretation of the entry.
Yes, interpretation of the entry, Lord, as also whether they are protected under Article 29, the effect of the presidential assent and challenge, if any challenge that is laid to it, that is, and whether the judgment is whether the law is brought in to nullify Nagaraj. That's the four essential heads to be left. I'm not, if I may just point out, Mr. Giri will be appearing in writ petition 25, Mr. Grover in 3 matters, which is Jellicut 2, and he's dealing with the anatomy of a bull. And
That
then
is the petition number?
that's writ petition 27 of 2016 and 6 of 2018 and 10 of 2018. But may I do this? I will give your lordship a chart like this for your convenience.
Yes.
It's there, but we'll just make copies of it because there's the one I have. So, and then there are some, but we divided it council wise who's appearing in what.
That's what we,
We'll give it to your lordship, Lord, in 5 minutes. I'll just get copies made. There are another about 4 petitions which are separate, Lord, which are distinct where there may be other council who may want to supplement. But this is the broad structure of the matters. There are 15 matters.
Same thing.
I'll just get that photocopied if your lordship permits.
you were on the writ petition 24,
24 is not 24.
which covers all the 3
All
amendments.
3, and I'm in writ petition civil 1059 of
Just
2017.
1 minute, writ petition.
1059 of 2017, which relates to Maharashtra.
No, but if 24 covers Maharashtra
My
also,
lord, yes.
then
Yes.
what is
Well,
the,
I'm just pointing out which are the matters I'm appearing. And 1152 of 2018, which relates to Karnataka. I will be treating them all together, Lord, under one umbrella, because really there are, since the first matter covers all legislation, so I will treat them as one. And that's the reason, Lord, we will just do this. We'll go straight away to that. Lord, if I may.
what would be your main thrust, whether Nagraj?
But yes, my main thrust, one of the main thrusts is going to be that Nagraj is sought to be overruled. Nagraj has, and the review, had determinations on fact, and those determination of fact have gone untrammeled, unchallenged, and they cannot be undone by this kind of legislative activity. Secondly, that the legislation as it stands, as it is sought to be brought out as excessive delegation, the reason is they brought in just the bare provisions and brought in everything within the rules. So the so-called exceptions that they create, or the protection that they create in terms of the activities to be carried out, whether Jallikattu or Kambala, it's not in the legislation. It comes out in the rules. Now, whether that can at all be done, that's the issue that is to be placed before your lordship. Third issue, and therefore,
But we always reminded that this is a repetition of Article 32.
I'm sorry, Lord.
This is a repetition. They're all petitions of Article 32.
Yes.
We are concerned with fundamental rights
Yes,
being enforced.
yes,
You're talking about challenging a law on the basis of delegated legislation being in excess. It's just telling you. You are
yes, of
aware
course,
it.
Lord. Lord, I must say this. We have taken a number of grounds in the petition, Lord, as to why these legislations have to fail. So there are alternate pleas which I will take, and I will just dwell on them in
On the basis of fundamental rights being violated.
but yes, of course, fundamental rights. But the whole issue is fundamental rights. The primary issue is fundamental rights, and that's the Nagaraj
The
principle.
whole question is whose fundamental rights?
Yes, but and that's been settled in Nagaraj. That's been settled. So not then the issue will be the personhood of animals upheld in
Do
Nagaraj.
you not address that first
Yes, Lord. I'll address.
and convince the court? that-
Yes, Lord, my friend Mr. Diwan is saying if your lordship could perhaps switch on or increase the volume because can't hear.
Not hearing.
Not hearing very. Yes, but now it's. Yes, but I'll come to personhood. I'm not on personhood. There are 2 things which I must point out. And if I will just come straight away to personhood, Lord, your lordship. Yes, there are 2 parts. Lord, one of course.
What's the matter?
One, of course, will be the Nagaraj principle, and those paras of Nagaraj I have not yet placed in entirety.
Not a citizen.
Yes, sir. Yes, of course, sir. No, I'm not on
There are
19.
certain rights available to non.
Yes, of course, sir.
Citizen, like Article 14 and
Yes, of
21.
course, sir. Yes, sir.
So 14 and 21 perhaps. Because it speaks about arbitrariness without being for the.
That is our, that's the submission, Lord.
So it's 14 and 21 we take.
Yes, Lord, 14 and 21.
Okay.
And Lord, I'm going to now place two things before your Lordship. Please consider two things, Lord. The first point that we seek to make is when the Constitution on this, on juristic personhood, and I'll begin with that. When the Constitution recognizes that cruelty to animals is to be an activity which ought not to be perpetrated, and that is the reason for entry 17 list 3, the Constitution recognizes the rights of animals. We have rights of animals under 48, 48A, 51, there are duties. And today, I don't need to really trouble your lordships to say that all of these will have to be read with part 3. They can't be read dehodes part 3. So
When you talk about, the environment, it immediately sort of call your attention to, for example, a tree.
yes,
Now, a tree, if you go to the extent of saying that no person shall be deprived of life and liberty. So the tree also will be a person. Because you're talking about animals, even plants have life, as your trees have life, as you know. In fact, there are studies which show that supposing an elephant is racing and it starts feeding on a particular tree, message goes. There's a mechanism by which the message goes to trees which are
Yes, of
located
course.
far away. And they start emitting a sort of poison. The anticipatory beam kind of thing, they sort of immediately know they're on their way to, so they are protected.
yes,
There are a lot of mechanisms involved in nature,
yes,
which if you limit it to animal today, just think of the prospect of the tree also being protected. In fact,
Yes.
there is one judgment in the Uttarakhand High Court, entered by, I think, Justice Rajiv Sharma, where he spoke about that trees having.
yes.
So you have to be a little careful about where we go.
No, not definitely.
Because in that even grazing might be an offense against
No,
the plants.
I completely understand. The reason I completely understand what your lordship is saying. But in fact, there are decisions of possibly of Justice Rajiv Sharma. The decision is that Muhammad Salim versus State of Uttarakhand, which was in relation to, which is part of the compilation which we've given to you.
That's right.
Similar, there are views taken. Some of those are actually under consideration before coordinate benches of your lordship's court. So we are not dwelling in that realm right now for the purpose of today.
Secondary argument, brothers, secondary point or primary point. In such a complex interplay of rights, would it not be safer to leave it to the legislature than taking us on ourselves the duty to categorize these rights?
But in fact, the rights with respect stand categorized. The rights stand explained in Nagaraj. Today, the question is going to arise, is this an attempt to overcome what your lordships have declared as the law? And is that permissible at all?
In cases that is permissible.
Not in, it is
What we
permissible if
declared
basis
in a
is the law.
judgment, there are many constitution amendments which are to invalidate.
Indeed, my
effect
lord.
of there are many legislative amendments to invalidate a court order.
Yes, but of course there are. But
So that is a permissible
my lord,
activity for the lawmaker in a constitutional form of government.
yes, but the only
Just
distinction.
because there has been a declaration of law, say the US example of recent thing,
Yes, of course.
something that happened 70 years back continued, but now the court felt that that is not right. So it doesn't become for all times to come. It's not a theory of gravity.
No, but the only distinction that I would draw is not that once there is a declaration, unless the basis of that decision is removed, in terms of the law that your lordships have settled Lord repeatedly on a number of occasions, the fact is under the basis of the decision is dealt with, or the concerns that your lordships hold are dealt with, the defects are cured, mere bringing in of a legislation will not suffice.
So there are two kinds of concern.
Yes, of
We
course.
can express certain kind of concern as individuals and certain kind of concern as judges.
But I was on the concern as judges. And I would say not that concerns.
Because many things we may not like as individual, but while putting on the robe and sitting on this chair,
I'm not, I
we might
completely
have
understand.
forfeit our own prejudice, biases, likes, dislikes, and take another course.
Definitely. I'm not, I was talking about not the individual philosophy of a person, whichever chair he or she may adorn, but about the declaration of law, declaration of the interpretation of constitutional principles and the declaration of law. Once there is a declaration of law by your lordships, that cannot be.
One small intervention there.
Yes.
That's it. See, Nagaraja was dealing with a different statute.
Yes, of course.
It was an attempt by the state to
That-
legislate, attempt to state to legislate, which finally it was found it was unsuccessful because it is a case of repugnancy under Article 254, number one.
Yes.
Now, regarding the repugnancy, you are right, they cannot be opened, therefore they have resorted to amending the act itself. Now, therefore, 11, there is no violation of section 11 as such, because nothing will subject to your challenge to 11 3F in the Tamil Nadu case. Supposing you succeed on any other ground, you are succeeding. Otherwise, it's part of the same statute today.
Not the.
Number one. Secondly, as far as the question relating to whether an animal is entitled to personhood under Article 21, that is not a matter which is not open to reconsideration at the hands of a larger bench.
Not at all, Lord.
That's what we want to be very clear. So it's not as if it is cast in stone that it cannot be heard that that is not correct. They are not bound by the two judges' bench.
No, I'm not, with respect, not there are.
They're just saying that, these are the two.
Not, I'm very candid, not, there is
You
no
can go on
issue.
now, otherwise.
There is no issue, not, if your lordship believes that it has to be looked at, we have to address that. I'm not saying.
You
it's
don't
not-
object to what they are doing.
But they would not like it to be cast in stone. I hope your lordship will treat it as cast in stone, but their argument is that it's not cast in stone.
Exactly.
And that's a proposition not which one has to deal with. So I have to not therefore.
So you proceed in your own way. I mean, now we have got,
Yes.
we have already, we are already behind by about 10 minutes, 15 minutes.
No.
10 minutes, we are late. We'll certainly give you the time.
I'm grateful. I'm most grateful. I'm not just two things. I had placed before your lordship two things. The proposition was in terms of Article 48, 48A, and 51A, F and G. I'm not going to, yes. GNH, I'm sorry, GNH, not a, no, GNH is what they say, it should be F and G. It should be F and G. GNH, I stand correct for GNH. My mistake. Now, not the point that we will begin with is, and our submission is that the right under 14 and 21 has to be informed by 48, 48 capital A, 51A, G and H. In this context, when we look at section 3 of the Act, section Number one, in this context, if your lordship sees section 3 of the Act, and let's have a look at that. What does section 3 say? Section 3 says, it shall be the duty of every person having the care to take all possible measures to ensure that the well-being of such children and then 11 different categories of what is cruelty, E to E, F, and M is very important. I read it on the last occasion, I'm going to reiterate that. solely with the view to providing entertainment, confines or in fact, it confines or causes to be confined any animal, including tying of an animal as a bait in a tiger or other species, so as to make it an object of prey, cites any animal to fight, 8, 11 MNN,
Yeah,
MNN lot,
correct.
N is organizing, uses or keeps or acts in the management of any place for animal fighting, or baiting any animal, or permits or offers any place to be so used, or receives money for admission of any other person to be any place kept or used for any purpose, or promotes part in punishment. What is also important is, my lordship comes back to L. Mutilates any animals or kills any animal, including stray dogs, by using the method of strychnine injection in the heart or any other unnecessary cruel manner. So, while the legislation recognizes that there are going to be instances, as we have referred to on the previous occasion in chapter 4 on experimentation with food, the legislature says you will not act in terms of any cruelty. And the whole purpose of that is to ensure that the purpose of the legislative entry and the purpose of the act is met. Now, when we look at these legislations, one of the things your lordship is going to look at is the legislation is to enhance or protect the interrelationship of men, animals, and nature. And that is what the purpose of this legislation, that is the purpose behind the constitutional provisions. In this context, as I said on the last occasion, we had the Wildlife Protection Act itself also, which came in. And the Wildlife Protection Act is another species of legislation. It is not that that legislation does not permit the culling of animals in certain circumstances. It does. For example, in the Wildlife Act, in the 5th schedule, there is in the 6th schedule, there are rats and animals. Give me the Wildlife Act. I'm not, if your lordship just sees for a moment, in the Wildlife Protection Act, there is the schedule. '62, please. Just have a look at section 62 for a moment. Chapter 62, declaration of certain wild animals to be vermin. The central government may by notification declare any wild animal other than those specified in Schedule 1 and Part 2 of Schedule 2 to be vermin for any area and for such period as may be specified therein, and for so long as such notification is in force, such wild animal shall be deemed to have been included in Schedule 5. Schedule 5, there is which talks about, and please note, Schedule 5 will possibly at page 86 of the Working Act. So, common clause, page 86.
Yeah,
Common crows, fruit bats, mice, and rats. These are permitted, provided there is a declaration, and it has to be area specific and place specific. I'm not, in this case, in this context, there was an issue which came up regarding the trade in ivory before this honorable court, and a 3-judges bench in 2003, 7 SCC, page 589. I've given the list of books. Just please give the book first. 2003-7 is, 2003-7 is, right? Yes.
This bad, provision. They will not be animals under the.
Not they're animals.
And protection and prevention authority and will
Not
not have rights under Article
No.
21.
No, Lord, they're animals. They're animals. May I just say this? They're animals. They have
The
rights.
later act, we are
Yes,
saying,
Lord. Yes.
85 Act is a later act.
Yes.
So animal is not defined as excluding vermin.
No, Lord. Let me just clarify.
It will go.
No, Lord, I'll just come to that. Lord, I'm sorry. The Prevention of Cruelty to Animals Act is the 1960 Act.
Oh, sorry.
1960 Act.
It's a subsequent act.
Lord, I'll just tell. The Wildlife Protection Act came in because earlier we used to have different legislations in different states. It was a state subject, then it came together. We had a comprehensive legislation. In that comprehensive legislation, we had a national legislation which has undergone number of changes. Initially, wildlife trade was regularized, controlled. Thereafter, there has been a prohibition. There's an 85 amendment, there's a 91 amendment, there's a 2002 amendment. There are various amendments. The purpose is what? That even because I'm going back to that wonderful example your lordship took of a mosquito, so to speak. So not the point is that there are instances where there is going to be what we may call not a man-animal conflict, to use the word which is used in the context of environment, but where there are rights. For example, not the dengue, the mosquito that spreads dengue, we use pesticides against it. If we were to take the example of not certain religious sects, they actually, when they move about, they cover their mouth so that no insect should go into their mouth also.
Absolutely.
Because there is a level of sensitivity to natural beings. But that is part of religion, that's part of a practice which is followed by certain community. Today, our concern is slightly different. Our concern is that how is it that we are to treat animals in its entirety, except for exceptions, as in, and that is the reason I said all legislations will have certain specified exceptions for a social or a public or a purpose related to the the rights to, when we balance the rights of humans and certain animals, that balance is there. But the point today is when the legislation itself contradicts the principle in the Constitution, both in Part 4 and therefore read with Part 3, as also with the fundamental duties, and this legislation acts contrary to the very purpose of the legislative entry and the purpose for which the original legislation was made out, how can we consider it to be a valid piece of legislation? And therefore, it is in that context that I'm saying, please consider what the basis entire of the Constitution and these legislations is compassion for animals, which is what is stated in the Constitution. And in this context, if I may just draw this court's attention to that 2003 judgment, para 51 for a moment.
One more small interjection.
Yes, of course, Lord.
Clear the air so that we have it in mind. The 1960 Act, as you said,
Yes,
gave rights to all animals under Section 11.
yes.
You say that the animals had the right under Article 21.
I'm sorry, Lord?
Animals, as defined in the Act,
Yes.
have rights under Article 21.
Yes.
If that is so, the Section 62 of the later Act, 1972, permitting animals to be condemned as vermin, which including Mickey Mouse, the rats, and the mouse and whatever, mice, that the crow which is black in color. So partly the reason why we don't know why it is being discriminated against. Will it not be will not those laws be violative of Article 21?
Lord, I'll tell your lordship straight away, Lord. Those laws, not as I said, not the exception is made for vermin. That does not change the rule that flows through the Wildlife Act. To put it in another example, my lord talked about not something which I have a little understanding of because I have lesser understanding of other laws. But my lord talked about anticipatory bail in 21. Now you take away somebody's life, you do it, though Article 21 says life is sacrosanct. We take away people's liberty.
That right has been maintained under 1960 Act, right of human being, for the
Yes.
purpose of religious or even for normal food habit. So that capital punishment for eating is permissible. If you treat them as a person.
Yes, please. Now, I understand, Lord, as I was saying, Lord, just to add, even under the Wildlife Act, Lord, and I must point out, it is not that hunting is prohibited in its entirety. Under Chapter 3, it is permitted in exceptional circumstances, and those are in a sense similar to the exemptions made under the Prevention of Cruelty to Animals Act.
Mr. Luthra, why we are bringing
Yes,
these
of course.
subjects up
Yes,
again
of
and
course.
again? See, this is not really a constitutionally protected domain. Legislature has interplayed with what is permissible, what is not permissible all through. In fact, when Constitution came, we don't think any of these animal protection law, except some in the maybe municipal laws, the scavenger birds,
No, Lord.
they were protected.
In fact, Lord, I must point out,
No, listen,
there was a legislation since it was
Maybe-
shortcomings,
may-
therefore your lordship.
maybe we are-
therefore the parliament got
we are not wrong. We haven't.
1890 Act.
Yes. So if the legislature has all along done this categorization about which animal should be totally free from cruelty, where partial cruelty can be there. Now, what is so special about the three legislations you are attacking
Yes.
that they should be treated as if it is a constitutional
I
right?
completely understand. Lord, I'll tell your lordship, the distinction has been made. While the legislature,
We are also saying this because all these legislations also takes protection of prevention of exceptional use of force or pain.
yes,
Now, whether they are breached or not, that's another question. That's a law and order question.
no, that's an issue of implementation. We are
Yes.
not in the course of
No.
implementation. The issue perhaps not will have to be
How will
seen.
you determine the expression or rather this necessary pain? They used such an expression, necessary pain or unnecessary. Unnecessary.
Yes. Now, Lord, I must tell your lordship, Lord, may I then come back to Nagaraj for a moment because Nagaraj deals with this issue, not on pain and
Unnecessary.
unnecessary. So let's have a look at that. Would your lordship just come to Nagaraj for a moment, Lord?
Plans as well.
Now, Lord, please come to
Taken plans as well. Going by the restrictions.
para 32, which is that page 580 of the report.
We need to tune it a bit.
Before I come to 32, Lord, your lordship may recall, no, just
I say is
Page 559, para 4. ABWI has taken the stand that by no stretch of imagination can it be gainsaid that Jallikattu, a bullock cart race conducted as such, has any historical, cultural, or religious significance either in the state of Tamil Nadu or in the state of Maharashtra, and even assuming so, the welfare legislation like PCA Act would supersede the same, being a parliamentary legislation. AWBI should be, has also taken up the specific stand that bulls involved in Jallikattu, bullock cart race, etc. are not performing animals within the meaning of 21 and 22 of the PCA Act, and that the MOEF in any view was justified in issuing the notification dated 11 July 2011, banning the exhibition of bulls or training them as performing animals on accepting the stand taken before this court. Then what para 5 is repugnancy, and 6 is the arguments by the other side saying that there's custom and there's a policy behind it. Now, number para 15, I would like your lordship to see. Organizers, bull tamers, bull racers, spectators, participants, or the respective states or the central government. Since we are dealing with a welfare legislation of a sentient being over which human beings have domination, and the standard we have to apply in deciding the issues on the hand is the species' best interest, subject to just exceptions out of human necessity. Number para 16 to 18 is the behavioral aspect. I won't trouble your lordship with that. I don't want to get into the consequences of the law that's set out in detail in the judgment. Please come straight away to para number 32. In fact, 31 first, probably place 31 and then 30. We have to examine page 580 of the report. That was the examination. We have to examine in the light of the above facts whether the events that are being conducted in the states of Tamil Nadu and Maharashtra are in violation of 311(1)(a), M, 21 and 22 of the PC Act, read with Articles 51(a) and G and H of the Constitution and the notification dated 11 July 2011. The PCA Act was enacted even before the introduction of Part 4A dealing with fundamental duties by the Constitutional 47th Amendment Act 1956. Earlier, the then British in India enacted the Prevention of Cruelty to Animals Act 1890 for the human beings to reap maximum gains by exploiting them with coercive methods, with an idea that the very existence of the animals is for the benefit of the human beings. During the course of administering the above mentioned act, many deficiencies were noticed by the Government of India, and a committee was constituted to investigate and suggest measures for prevention of cruelty to animals. Following that, a bill was introduced in Parliament, and ultimately PC Act 1960 was enacted so as to prevent the infliction of unnecessary pain or suffering on animals and to amend the law relating to prevention of cruelty to animals. So, Lord, I'm going to pause here and say your lordships are testing whether the pain that is to be caused is necessary or not, because the state says it's necessary and they will have to justify by what means of justification can they say that this is necessary. Is it not a case of trivializing and acting contrary to what the original legislation did? Now, let's read a little further. The PCA Act is a welfare legislation which has to be construed, bearing in mind the purpose and object of the Act and the directive principles of state policy. It is straight law that in the matters of welfare legislation, the provisions of law should be liberally construed in favor of the weak and infirm. The court also should be vigilant to see that benefits conferred by such remedial and welfare legislation are not defeated by subtle devices. The court has got the duty that in every case where ingenuity is expanded to avoid welfare legislations, to get behind the smokescreen and discover the true state of affairs, the court can go behind the form and see the substance of the device for which it has to pierce the veil and examine whether the guidelines or the regulations are framed so as to achieve some other purpose than the welfare of animals. Regulations or guidelines, whether statutory or otherwise, if they purport to dilute or defeat the welfare legislation and the constitutional principles, the court should not hesitate to strike them down so as to achieve the ultimate object and purpose of the welfare legislation. The court also has a duty under the doctrine of parens patriae to take care of the rights of animals, since they are unable to take care of themselves as against human beings. The PCA Act, as already indicated, was enacted to prevent the infliction of unnecessary pain, suffering, or cruelty on animals. 3 of the Act deals with duties of person having charge of animals, which is mandatory in nature and hence confer corresponding rights on animals. Rights so conferred on animals are thus the antithesis of a duty, and if those rights are violated, law will enforce those rights with legal sanction. Then Section 3 is extracted. I'm not pleased to overleaf. Both the above limbs have to be cumulatively satisfied. Primary duty of the person in charge or care of the animal is to ensure the well-being of the animal. Well-being means state of being comfortable, healthy, or happy. Forcing the bull, keeping the same in the waiting area for a number of hours, subjecting it to scorching sun is not for the well-being. Forcing and pulling bull by nose ropes into the narrow closed enclosure of Wadi Wasal, subjecting it to all forms of torture, fear, pain, and suffering by forcing it to go to the arena and also overpowering it at the arena by the bull tamers are not for the well-being of the animal. The manner in which the bull tamers are treating the bulls in the arena is evident from the reports filed by the AWBI. Forcing the bull into the Wadi Wasal and then into the arena by no stretch of imagination can be said to be for the well-being of such animals. Organizers of Jallikattu are depriving the rights guaranteed to the bulls under Section 3 of the PCA Act. Sadism and perversity is writ large in the actions of the organizers of Jallikattu, and the event is meant not for the well-being of the animal, but for the pleasure and enjoyment of human beings, particularly the organizers and spectators. Organizers of Jallikattu feel that their bulls have only instrumental value to them, forgetting their intrinsic worth. First limb of Section 3, as already indicated, gives a corresponding right to the animal to ensure its well-being. AWBI, a body established to look after the welfare of the animals, has to see that the person in charge of the animals looks after their well-being. We have no hesitation to say that Jallikattu, bullock cart race as such, is not for the well-being of the animal, and by undertaking such events, organizers are clearly violating the first limb of 3 of the Act. This is a very crucial point. This is a finding of fact on the nature of the activity. This is not the repugnancy issue. This has got untrammeled blood, and that is the point that we were seeking to make. 36 note. We will now examine whether the second limb of Section 3, which casts a duty on the person in charge or care of an animal to prevent the infliction upon an animal unnecessary pain or suffering, discharges that duty. Considerations which are relevant to determine whether the suffering is unnecessary, including whether suffering could have reasonably been avoided or reduced, whether the conduct which caused suffering was in compliance with any relevant enactment. Another aspect to be examined is whether the conduct causing the suffering was for a legitimate purpose, which is such as the purpose for benefiting the animals or the purpose of protecting a person, property, or other animal, etc. Duty is to prevent the infliction of unnecessary pain or suffering, meaning thereby no right is conferred to inflict necessary unnecessary pain or suffering to the animals. By organizing Jallikattu and bullock cart race, the organizers are not preventing the infliction of unnecessary pain or suffering, but they are inflicting pain and suffering on the bulls, which they are legally obliged to prevent. Section 3 is a preventive provision, casting no right on the organizers, but only duties and obligations. Section 3, as already indicated, confers corresponding rights on the animals as against the person in charge of care as well as AWBI to ensure their well-being and be not inflicted with any unnecessary pain or suffering. Jallikattu or bullock cart race from the point of the animals is not an event ensuring their well-being or an event meant to prevent the infliction of unnecessary pain or suffering. On the contrary, it is an event against their well-being and causes unnecessary pain and suffering on them. Hence, the 2 limbs of 3 of the PC Act have been violated while conducting Jallikattu and bullock cart race. Lord, please come to just para 14, Lord. Excuse me. Pain and suffering are biological traits. Pain in particular informs an animal with specific stimuli it needs to avoid, and an animal in pain has pain receptors and a memory that allows it to remember what caused the pain. Lord, please come to 41, Doctrine of Necessity. 11.3 carves out exceptions in 5 categories of cases mentioned in 11.3a to E, which are as follows. Lord, nothing in this section should apply to the dehorning of cattle or not castration. I've read these to your lordship earlier, so I don't need to repeat that. Exceptions are incorporated. Next page. Exceptions are incorporated based on the doctrine of necessity. Clause B to section 11.3 deals with the destruction of stray dogs out of necessity. Otherwise, it would be harmful to human beings. Clause D of section 11.3 deals with matters within chapter 4 incorporated out of necessity, which deals with experimentation on animals, which is for the purpose of advancement by new discovery of physiological knowledge or of knowledge which would be useful for saving or prolonging life or alleviating suffering or for combating any disease, whether of human beings, animals, or plants, which is not prohibited and is lawful. Clause E to 11.3 permits killing of animals as food for mankind, of course, without inflicting unnecessary pain or suffering, which clause is also incorporated out of necessity. Experimenting on animals and eating their flesh are stated to be 2 more major forms of speciesism in our society. Over and above, the legislature, by virtue of 28, has favored killing animals in a manner required by the religion of any community. Entertainment, exhibition, or amusement do not fall under these exempted categories and cannot be claimed as a matter of right under the doctrine of necessity. Section 311 is already indicated, therefore confers no right on the organizers of Jallikattu or bullock cart race, but only duties, responsibilities, and obligations, but confer corresponding rights on animals. 311(1)(a) and A and O and other related provisions have to be understood and read along with 51 AG of the Constitution, which casts fundamental duties on every citizen to have compassion for living creatures. Parliament, by incorporating 51 AG, has again reiterated and re-emphasized the fundamental duties on human beings towards every living creature, which evidently takes in bulls as well. All living creatures have inherent dignity and a right to live peacefully and right to protect their well-being, which encompasses protection from beating, kicking, overdriving, overloading, torture, pain, suffering. Human life, we often say, is not like animal existence, a view having anthropocentric bias, forgetting the fact that animals have also got intrinsic worth and value. 3 of the PC Act has acknowledged those rights, and the said section, along with section 11A, 11 casts a duty on persons having charge or care of animals to take reasonable measures to ensure well-being of the animals and to prevent infliction of unnecessary pain and suffering. Para 43. All animals are not anatomically designed to be performing animals. Bulls are basically draught and pack animals. They are livestock used for farming and agricultural purposes like plowing, transportation, etc. Bulls, it may be noted, have been recognized as draught and pack animals in the Prevention of Cruelty to Draught and Pack Animals Rules 1965. Draught animals means an animal used for pulling heavy loads. The rules define large bullock to mean a bullock the weight of which exceeds 350 kg. Bullocks have a large abdomen and thorax, and the entire body has a resemblance to a barrel shape which limits the ability to run. Bulls also have limitations in flexing joints, and rigid, heavily built body and limited flexion of joints do not favor running faster. Due to the body constitution, the Prevention of Cruelty to Animals, Transport of Animals on Foot Rules 2001, especially Rule 11 says that no person shall use a whip or a stick in order to force the animal to walk or to hasten the pace of their walk. Bulls, it may be noted, are cloven-footed, 2-digit animals, and 2-digit in each leg can comfortably bear weight only when they are walking, not running. Horse, on the other hand, is a solid-hoofed, plant-eating quadruped with a flowing mane and tail, domesticated for riding and as a draught animal. Horsepower, as we call it, is an imperial unit of power equals to 550 foot-pound per second. Horse's anatomy enables it to make use of speed and can be usefully used for horse racing, unlike bulls. Bulls, therefore, in our view, cannot be performing animals, anatomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of 3 and 11(1) of the PC Act. Chapter 5 of the PC Act deals with performing animals. Section 22 places restriction on exhibition and training of the animals, which reads as under. I'm not the point I seek to make this. These are scientific findings which have they have not been untouched, and the amendments do not take into consideration these scientific findings. The amendments simply carve out an exception to 3 and 11 to say that we will allow the relevant sports, and there is no concern or consideration to deal with these aspects. Now, Lord, kindly just see 48 and 49 for a moment. Lord, we'll just place 47 as well, Lord. The performing animals rules, because your Lordship had put that question on ticketing, define performing animal to mean any animal which is used at for the purpose of any entertainment to which public are admitted through sale of tickets, Jallikattu, bullock cart racing. Without sale of tickets, and hence 22 of the Act would not apply. So also the notification dated 11 July 2011. We find no substance or logic in that submission. It may be noted that when a bull is specifically prohibited to be exhibited or trained for performance, the question whether such performance, exhibition, or entertainment is conducted with sale of tickets or not is irrelevant from the point of application of 3 and 11(1) of the PC Act. Then, Lord, 48, just read the portion below the provision quoted. 11(1)(m)(2) therefore says that if any person solely with the view to providing entertainment incites any animal to fight, shall be punishable under the proviso of 11(1). In Jallikattu, a bull is expected to fight with various bull tamers, for which it is incited solely to provide entertainment for the spectators by sale of tickets or otherwise. Inciting the bull to fight with another animal or human being matters little so far as the bull is concerned. It is a fight, hence cruelty. Jallikattu, bullock cart race, therefore violate not only 3(11)(1)(a)(m) and section 22, but also the notification dated 11 July 2011 issued by the central government under 22(2) of the PC Act. I may just add not that notification is still in force. We may, 49, we may in this connection also refer to the performing animal registration rules. Rule 8 deals with the general conditions of registration. Rule 8(1)(5) states that the owner shall ensure that any animal is not inflicted unnecessary pain or suffering before or during or after its training or exhibition. 8(1)(7) specifically cautions that owner shall train the animal as a performing animal to perform an act in accordance with the animal's natural instinct. A bull is trained not in accordance with its natural instinct for the Jallikattu or bullock cart race. Bulls in those events are observed to carry out a flight response, running away from the crowd as well as from the bull tamers. Since they are in fear and distress, this natural instinct is being exploited. But in fact, there was an affidavit at that state filed at page para 50, and the relevant portion is from the AWBI. Please see the quoted portion. I affirm on behalf of the Animal Welfare Board of India that Jallikattu is indeed an extremely cruel and barbaric sport in which bulls are forced to participate, are brutalized and subjected to unnecessary pain and suffering. Surrounded by huge crowds of screaming, shouting people intent upon them, cruelly subdued and overpowered, regardless of what they endure, the bulls are subjected to terrible acts of cruelty. Then Lord, beaten, kicked, chili powder, etc., rubbed into the eyes. All of this, I don't want to just come to the italicized portion. Just 3 lines above that. By no stretch of imagination can bulls be termed as performing animals or trained for the sport. In fact, what occurs during the event is that the participating bulls are forced to endure unnecessary pain and suffering beyond measure. It is for this reason that the answering respondent had represented to the central government that this barbaric prehistoric event masquerading under the guise of sport be banned. Then not there is
Siddharth.
more about the other act. I won't trouble.
Siddharth, our request. After the amendments are made subsequent to this judgment which you are reading to us, all the three states are very conscious. Section 3 of the Act, Substantive Act, is 60. They have come out with rules.
Mhm.
Taking Section 11 and Section 3 put together, cruelty is defined
Yes,
and how the safety of animal can be there.
yes,
They have prescribed certain rules.
yes, ma'am.
Now, this is a balancing between the two. There should be no cruelty. At the same time, they may continue with their long festivals and traditions they are following in the respective states. Now, our question to you is, when this court was examining this judgment which you read to us,
Mhm.
what were the rules? Is the rules as the state have now come forward prescribing in the respective states?
Similar.
The same rules were there at a given point of time under the 60 Act.
Not what they did was when they, no, Lord, I must tell your lordship, under the 60 Act, these sports were not permitted. Then they come in with the state amendment, the TNRG Act, not which the state law comes in. And essentially, I've got that comparison. It's not really similar. There's no real, just keep.
All the three states took assent from the president.
No, Lord, I'm sorry, Lord.
All the three states with their state amendment took assent from the president.
Yes, Lord.
And for the safety and other purpose of the animals, they have come out with their rules
Yes, Lord.
as to how it has to be implemented and regulated.
Yes. Lord. And those are not, if I may say so, what was dealt with in Nagaraj and what is now sought to be brought in as so-called safety measures is really similar. Not there is no real change. It's just that now the path is a little different. It's a little more sophisticated, but sophistication may not alone save it, Lord, because the question will be, and this is another issue which your lordship will deal with. What was placed before the president? Were these issues placed? Because that aspect, while president assent is one issue, not, but that aspect your lordship will look at and see. They have only given us one document, and I'll just show your lordship that one document they've given us. Just show that one document, because we have tried to understand what as to what was placed. All they do is for Maharashtra, and I'll just give your lordship the page number. The convenience compilation by Maharashtra, annexure A11 at page 38, just says that, just as the letter saying, state government's letter on the subject to return to authenticated copies with the president's assent, nothing mentioned. And it's described as the presidential assent, no details as to what was sent to the president, because that becomes very crucial. Your lordship has now brought in series of decisions said, when you want to overcome a situation, whether it be by way of a judgment of this court or otherwise, and you're bringing in a legislation, you're bringing it, and you're seeking presidential assent, you will have to say, what is it that, what purpose was sought to be, what was the purpose that was placed before the president? And that aspect is completely silent on that. Just one line, presidential assent granted. We don't know whether they'd explained the contours of Nagaraj to the president, they placed the contours of Nagaraj, as also the findings of fact. And even since your lordship raised the issue of cultural rights, I was just going to take you straight to para 53 of Nagaraj, which deals with the issue of culture. So not even for culture, there will be two parts. One, Nagaraj deals with it. Secondly, on culture, there is no finding, there is no material placed by them at any point of time to justify then or now, to justify that this is part of culture. Because eventually, not if you take an argument, this is a cultural right.
That can't be open for us.
But your lordship has seen it.
Go to examine.
But is it not your lordship? Not like I'll place the
The
law.
legislative competence.
Not your lordship. No, not your lordship will consider whether something is part of culture. Not, for example, and I must say this. Not. I'll give your lordship the example straight away. Not for example, and I'll give the example. Not Sati, for example, was supposed to be part of culture. Legislation came in. There have been other issues which are stated to be part of culture, but they have to prove a cultural practice. They have to establish that cultural practice, and that's the law. Not the Dowry Prohibition Act came in. Not at one point, dowry was supposed to be part of culture. The legislation came in. Child marriage was done away with. Widow remarriage was done away with. The law.
These were all through legislative process.
But they were through legislative processes. But the point I,
This is not the.
my lord,
These are on judicial process.
my lord, I appreciate. Not today. All I'm pointing out to your lordship is, while you're looking at it in judicial process,
Indictment tomorrow legislature says that this is prohibited, we have nothing to.
Not, it's like this. It's not, I completely understand. It's like this, not? Does it lie with a citizen or section of citizens to claim that something is their right? And if the legislature says that something is accepted as a cultural practice, our case is there has to be the existence of a cultural practice to accept it. A mere activity does not gain the status of a fundamental right or part of Article 29 rights merely because it is an assertion. That will have to be tested by your lordship, because today we are saying there is no basis to say it's a cultural right. And in
You are inviting us to test the legislative wisdom.
no, Lord.
That is a risky.
No, Lord, I'm inviting your lordship to test it in line of the question framed on 29, whether this is protected under 29 or not. Now, that is a question which has been framed, which I hope your lordship will consider answering. And in that context, not just come back to Nagaraj at para 53 for a moment.
Oh, Nagaraj, you read over to us.
I'm sorry, Lord.
The whole Nagaraj judgment you read.
No, Lord, there are a couple of things.
Para 53 is,
But since one of the questions is framed on Nagaraj, Lord, I'll have to place it.
para 53, you want to give stress to that to show that what was the practice or as part of the culture is
Yes,
different.
Yes, Lord. No, Lord,
That is totally different.
yes, Lord. So, Lord, there are two parts to it. 53 says that 53, 54, and then 55, Lord, and 56. And I'll just read these four paras. The statements and objects and reasons of the TNRG Act refer to the ancient culture and tradition and does not state that it has any religious significance. This is my Lord Justice Stogi have para 53, Lord, at page 589 of the report. Your Lordship sees it. Even the ancient culture and tradition do not support the conduct of Jallikattu bullock cart race in the form in which they are being conducted at present. Welfare and well-being of the bull is Tamil culture and tradition. They do not approve of infliction of any pain, suffering on the bulls. On the other hand, Tamil tradition and culture are to worship the bull, and the bull is also considered as the vehicle of Lord Shiva. Yeru Tazu in Tamil tradition is to embrace bulls and not overpowering the bull to show human bravery. Jallikattu means silver or gold coins to the bull's horns. And in olden days, those who got the money to the bull's horn would marry the daughter of the owner. Jallikattu, or the bullock cart race as practiced now, has never been the tradition of Tamil Nadu. The PC Act, a welfare legislation in our view, overshadows or overrides the so-called tradition and culture, Jallikattu and bullock cart races, the manner in which they are conducted. Yes, Lord. Yes, Lord, I was saying Jallikattu and bullock cart races, the manner in which they are conducted, have no support of Tamil tradition or culture. Assuming it has been in vogue for quite some time, in our view, the same should give way to their welfare legislation like the PC Act, which has been enacted to prevent infliction of unnecessary pain or suffering on animals and confer duties and obligations on persons in charge of animals. Of late, there have been attempts at certain quarters to reap maximum gains, and the animals are being exploited by human beings by using coercive methods and inflicting unnecessary pain for pleasure, amusement, and enjoyment. We have a history of doing away with such evil practices in society. Assuming such practices have the support of culture and tradition as tried to be projected in the TNRG Act. Salmon states that custom is the embodiment of those principles which have commended themselves to the national conscience as to the principles of justice and public utility. This court in Adityan, while examining the scope of Articles 25, 26, 26b, 17, 14, 21, held as follows. Quote, any custom or usage, irrespective of even any proof of their existence in pre-constitutional days, cannot be countenanced as a source of law to claim any rights when it is found to violate human rights, dignity, social equality, and specific mandate of the Constitution and law made by Parliament. No usage which is found to be pernicious and considered to be in derogation of the law of the land or opposed to public policy or social decency can be accepted or upheld by courts in the country. So that was a case, if I may remind your lordships, where the issue was whether a non-Brahmin individual could be a priest in a temple. And the question was that a person is to be a person of learning. And they said there is no such permission in the law. in the customs. In as early as 1500 to 1600 BC, in Isha Ushpanits, it is professed as follows: the universe, along with its creatures, belongs to the land. No creature is superior to another. Human beings should not be above nature. Let no one species encroach over the rights and privileges of other species. In our view, this is the culture and tradition of the country, particularly the states of Tamil Nadu and Maharashtra. The PC Act has been enacted with an object to safeguard the welfare of animals and evidently to cure some mischief and age-old practices so as to bring into effect some type of reform based on eco-centric principles, recognizing the intrinsic worth, value and worth of the animals. All the same, the act has taken place as something. About straight away to 73. 71. 71 at page 595. We have, however, lot of avoidable non-essential human activities like bullock cart race, jallikattu, etc., both thinking that they have only instrumental value are intentionally used, though avoidable, non-essential human activities, ignoring welfare of the bull solely for human pleasure. Such avoidable human activities violates rights guaranteed to them under 3 and 11 of the PC Act. AWBI expert body has taken up the stand that events like jallikattu, bullock cart race inherently involve pain and suffering, which involve both physical and mental combination distress. And Lord, there's a quotation from a judgment from a book which says, single worst thing you can do to an animal emotionally is to make it afraid. Fear is so bad for animals, I think it is worse than pain. I always get surprised looks when I say this. If you give most people a choice between pain and fear, they'd probably pick fear. Both anxiety and fear, therefore, play an important role in animal suffering, which is a part and parcel of events like jallikattu, bullock cart race. Now, not the right to life argument, 72. Every species has a right to life and security subject to the law of the land, which includes depriving its life out of human necessity. Article 21 of the Constitution, while safeguarding the rights of human life, has been good. And any disturbance from the basic environment, which includes all forms of life, including animal life, which are necessary for human life, fall within the meaning of 21 of the Constitution. So far as animals are concerned in our view, life means something more than mere survival or existence or instrumental value for human beings, but to lead a life with intrinsic worth, honor, and dignity. Animals' well-being and welfare have been statutorily recognized under 3 and 11 and the rights framed under the Act. Right to live in a healthy and clean atmosphere and right to get protection from human beings against inflicting unnecessary pain or suffering is a right guaranteed to the animals under 311 of the Act, read with 51 AG. Right to get food, shelter is also guaranteed right under 311 and the rules framed thereunder, especially when they are domesticated. The right to dignity and fair treatment is therefore not confined to human beings alone, but to animals as well. The right not to be beaten, kicked, overridden, loaded is also right recognized by 11 read with 3. Animals also have a right against human beings not to be tortured and against infliction of unnecessary pain or suffering. Penalty or violation of these rights are insignificant since laws are made by humans. Punishment is not commensurate with the gravity, hence being violated with impunity, hence the necessity of taking disciplinary action, etc. 73. Jallikattu and other forms of bull's race, as the various reports indicate, cause considerable pain, stress, and strain on the bulls. Bulls in such events not only remove their head, showing that they do not want to go to the arena, but as pain inflicted in the Vadi Vasal is so much, they have no other go but to flee to a situation which is adverse to them. Bulls in that situation are stressed, exhausted, injured, and humiliated. Frustration of the bulls is noticeable in their vocalization, and looking at the facial expressions of the bull, ethologist or any ordinary man can easily sense their suffering. Bulls otherwise are very peaceful animals dedicating their life for human use and requirement, but they are subjected to such an ordeal that not only inflicts serious suffering on them, but also forces them to behave in ways they do not behave, force them into the event which does not look like, and in that process they're being tortured to the hilt. Bulls cannot carry the so-called performance without being exhausted, injured, tortured, or humiliated. Bulls are also intentionally subjected to fear, injury, both mentally and physically, and put to unnecessary stress and strain for human pleasure and enjoyment, and that to a species which has totally dedicated its life for human benefit out of necessity. Sorry. We are therefore of the view that 21 and 22 of the PC Act and the relevant provisions have to be understood in the light of rights conferred on animals under 3 read with 11(1) A and O and Article 51 G and H. And as so read in our view, bulls cannot be used as performing animals for Jallikattu and bullock cart race, since they are basically draught and pack animals not anatomically designed for such performances. Lord, this was the essence of the Nagaraj judgment. And our submission is Nagaraj recognizes the right of animals to be kept in a safe environment. It says it's definitely a right by legislation, but it then relates the legislation to constitutional provisions. And my respectful submission, I don't need to, it's like taking coal to Newcastle, but just two illustrative decisions, Lord, on directive principles to be read into fundamental rights. I just place those two decisions. One is Minerva Mills and a few paras, Lord, of state that Gujarat, Mirzapur, Moti, Qureshi, Kasar case. I'll just come to Lord, 2005 8 SCC 534, because that will cover the Minerva Mill principles. It's
See, as a principle, directive principle and fundamental rights are interrelated, or directive principles may be on a higher plane sometime. That we have no problem in
yes, Lord.
accepting.
Yes, Lord.
But
So, Lord, the context.
51AG is also clear.
Yes, Lord.
Article 21, is there any other precedent?
Lord, I
Or
was.
was
Lord,
there any debate in the Constituent Assembly that this shall extend to the animals or anything like that? Or is it coming here for the first time?
But if I may say so, Lord, we had in the constitution really the provisions regarding the protection of cow progeny. That to that extent there was a debate. Lord. To that extent there was a debate in relation to
No, cow protection, then it went into the directive
that was there.
principle.
That was there. Now, Lord, the only thing that your lordship will see is in this decision, because this Mirzapur case interestingly deals with cows and cow progeny, Lord, and this was your lordship recalls that case in relation to slaughter, Lord, and the animal preservation.
Is there any authority before this in which it has been held that an animal is entitled to protection under Article 21?
But I would say, but not really from the Supreme Court. There are a number of High Court decisions prior to this, and then there are subsequent decisions also which have followed Nagaraj. I've got those. Just give me that.
No, pre-Nagaraj.
Pre-Nagaraj, there are decisions of different High Courts, but those are there. I'll just tell you,
You
Lord.
just give us the passage and
I'll give your lordship, Lord. Lord, they are pre-Nagaraj. I'll tell your lordship the decisions are, if I may just point out, if you're kind enough just to see volume 1 of the compilation of judgments, just have a look at the index straight.
It's clear about that.
because if Article 21 cannot be invoked for protection of animals, then Minerva Mills and that line of authorities become redundant so far as this litigation.
Lord, I will show your lordship in Mirza. I'll show your lordship. There's some passage in Mirzapur Motikasa which will be important, but we'll come to that. That's why I'm saying this follows Minerva. But your lordship put a question to me. Please see the index, Lord. Serial number 10 onwards, volume. Serial number 10 in the index, Lord. Just have a look at the index. Compilation of judgments.
Yes.
Lord, serial number 10 onwards. This is Lord, the decision, Lord, Gujarat High Court 2012. Lord. There's a heading analysis. It deals with the analysis. at page 472 of the compilation. Then Lord, then you'll have serial number 11, para 805 and 8.05, 8.06. Gujarat High Court again.
No, this
Yes.
analysis, what is the 21 point?
Lord,
Article
Lord, there's
21.
no specific reference to 21, Lord, but there were judgments which recognize rights of animals.
The rights of the animals, statutory right. There's no
It's what is
dispute
related to
on that.
51 AGM, Lord. Now, Lord, so there is one line there, Lord, without specifically referring to 21. Does your Lordship have? I'll place that just a moment. Does your Lordship have that?
Which one?
Lord, if your Lordship looks at page 472,
Yes. That analysis.
yes, Lord, second para, without referring to 21 specifically, using the saying 21, it says, we are considering this matter from a little wider horizon. Cattle, like human beings, possess life in them. Even an animal has the right to say that its liberty cannot be deprived except in accordance with law. Then we have noted that there are many enactments which recognize rights of animals. Then 51A comes just above the Supreme Court decision.
So on 21, there is no authority really before this.
No, Lord, if I may just say, not specifically referring to 21, Lord, there will be again at 482 passages not regarding birds, 805 and 806.
They are like human being, all the migratory birds will require visa and passport.
And then, my Lord, there will be the judgment. There's not 805, 806, and my Leonard, please point out 811. No, 811 is on the definition. Yes, Lord. 811, Lord, about the sixth line from the top. As stated above, every bird animal has the right to move freely. It cannot be disputed that so far birds are concerned, they have a right to move freely in the open air. Then, Lord, there is a judgment. Yes, for judgment is also there. Lord, this is Kerala, Lord, which your Lordship will see. And para 13. Before para 13,
Para 30.
13, Lord, 13.
The Goa judgment.
No, Lord, this is, Lord, I'm not your Lordship will be looking at. Goa, Lord, that's Goa judgment is para 7. Goa judgment is para 7. But that Goa judgment is the one, Lord, which I've told your Lordship. I'm sorry. Wait, just a moment, Lord. I'm sorry, I've got just a minute. Yes, but Goa judgment is, I'm sorry, 505, my mistake. Para 11 and 13. Same reasoning, Lord. Para 11 talks about cruelty at page 509. Para 13 talks about bullfights and how they are cruel in how animals are injured and have to be put to sleep because of this. This is in the context of bullfights. And please see 21, Lord, para 21 of this judgment, the Goa judgment. Is your Lordship of 21 at 512? That's the closest note to 21 rights. It cannot be disputed that all animals are born with an equal claim for life without any cruelty to them. Perhaps if this right was given proper recognition by human beings, there would have been no necessity to bring a statute book the Act. Unfortunately, even though the Act has been brought in force, there still appears to be lack of courage or negligence, and therefore, in our consideration, petitions are justified in making a grievance of the same. So, Lord, that is the closest where it talks about. All of them will mention the life, the right to live with dignity of animals, but they don't specifically refer to 21. But to that extent, 21 is referred. But one more thing, my learned colleagues want me to place is 497, the NR Nair judgment, para 13 at 497.
No person should be deprived of his life.
Housed in cramped cages, subjected to fear, hunger, pain, not to mention undignified way of life that they have to live with no respite. Impugned notification has been issued in conformity with the changing scenario. Values of human life, philosophy of the Constitution, prevailing conditions, surroundings, circumstances to prevent unnecessary pain. Though not Homo sapiens, they are also entitled to dignified existence and inhumane treatments, from cruelty and torture. This has been upheld by the Supreme Court at page 499. And para 11, your lordship's view in NR Nair law. Para 11 at 503, and if your lordship looks at classical C, that apart, it is the welfare of animals which is of paramount consideration. And it is only if the government is satisfied on the basis of materials that unnecessary pain or suffering is inflicted during course of training at the time when it is exhibited that it needs. The reading of the Act, 2 lines below, reading of the Act as a whole shows that 22, the necessity for the government to come to a conclusion that if a notification under the section is not issued, there would be unnecessary pain or suffering in training or exhibition. The existence of fact is a precondition to existence of notification. Not that was in relation to surfaces. So these are all pre-Nagaraj decisions. There are a number of post-Nagaraj decisions as well, Lord, and those are also part of the compilation, but they really follow Nagaraj.
That's okay.
Mr. Luthra,
Yes.
before you proceed away from Nagaraj, certain physical attributes of the bulls were mentioned in paragraph 43 by Justice Radhakrishnan.
Yes.
Now, are you assuring this court that bulls have not embraced any of the latest fashion trends of trying to be slim or, are you assuring this court of that? That since 2014, bulls have not caught on to the trends of today?
But if they have, then in the
You don't have to give a serious answer.
But I must tell your lordship, not on a lighter note, Lord, I have not been able to be slimmer, Lord. So I'm sure the bulls are not that successful either. I'm trying, but I'm not achieving it. Five 34 decision, Lord, which is at page 177 of the compilation.
Yeah. Just 1 minute. The PC Act, ACA Act 1960, it defines animal 2A. It means any living creature other than a human being.
Yes,
Other than a human being.
yes, my lord.
And now come to Article 21.
Yes, my lord.
No person shall be deprived. And the next word, his life.
Yes, my lord.
So, do you mean to say that his should be taken as the life of these animals also? How will you connect this with, especially in the light of the definition 2A?
My lord, therefore the argument.
It means a human being totally excluded. And now 21, how you will
Lord, in fact, Lord, but Lord, I appreciate what your lordship says, Lord.
because it only says no person shall be deprived of his life or liberty, except in accordance according to the procedure established by
Very
law.
true, Lord.
How
How we correlate the two? Lord, the answer is, to my mind, not very straightforward. By an interpretative process, your lordships have recognized the personhood of animals. It is not that your lordship says that animals are meant only for the use of human beings. There is a line of use as culminated in Nagaraj that we have changed from an anthropocentric, that is a human-oriented approach of legislation, of looking at of environment, of looking at animals, looking at wildlife, to an ecocentric approach where we look at the focus of what is
to say that they got a right under section 3 of this act, that's something different. But how will you put it under 21?
that we are bringing in through, that we seek to bring in through, so the purpose of not personhood through not 48, 48A and 51, and that was the decision not in Muhammad Salim's case by the Uttarakhand High Court. May I just place that for your lordship's consideration? That is not in volume 2. Volume 2. Serial number 18. Serial number 18 at page number 684, and kindly look at the relevant page being, my lord, para 689, para 14 first will read. (688) para 14. Not para 14 at 688. Does your lordship have 688?
Yes.
But 688 will quote a judgment, and I read that portion, then I'll come to the relevant para. In 2004, volume 4, SCC 146, their lordships of Honorable Supreme Court in the case of Shiromani Gurdwara Prabandhak Committee Amritsar versus Shri Somnath Das have held that the concept juristic person arose out of necessities in the human development. Recognition of an entity as a juristic person is for subserving the needs and faith of society. Then, Lord, it quotes para 11, and I will bring your lordship straight away to para number 14 of the quoted portion at page 689 bottom. This, Lord, I must say, is pending consideration and stayed by your lordship, but I'm placing it. Thus, it is well settled and confirmed by the authorities and jurisprudence in courts of various countries that for a bigger thrust of socio-political scientific development, evolution of a fictional personality to be a juristic person became inevitable. This may be an entity, living, inanimate objects or things. It may be a religious institution or any useful unit which may impel the courts to recognize this. This recognition is for subserving the needs and faith of society. A juristic person, like any other natural person, is in law also conferred with rights and obligation and is dealt with in accordance with law. In other words, the entity acts like a natural person, but only through a designated person whose acts are processed within the ambit of law. But then it gets into juristic persons, idols, etc. These come straight away to para 16. That was the quoted portion of Gurdwara Prabandhak Committee, but para 16 now. With the development of society, where interaction of individuals fell short to upsurge the social development, the concept of juristic person was devised and created by human laws for the purpose of society. A juristic person, like other natural person, is in law also conferred with rights and obligations and is dealt with in accordance with law. In other words, the entity acts like a natural person, but only through a designated person. As the lordships have held in the judgment cited above, that for a bigger thrust of socio-political scientific development, evolution of a fictional personality to be a juristic person becomes inevitable. This may be an entity, living, inanimate objects or things. It may be recognized religious institutions or any such useful unit which may impel the court to recognize it. The recognition is for subserving the need and faith of society. Corpus Juris Secundum, Volume 6, Paris so explains the concept of juristic persons, artificial persons, thus. Artificial persons, such as are created and devised by human laws for the purpose of society, are called corporations of already protected. Juristic person can be any subject matter other than a human being to which the law attributes personality for good and sufficient reasons. Juristic person being the creation of the law, as many juristic persons have been created by law as society requires for its development. Thus, to protect recognition and faith of societies, rivers Ganga and Yamuna are required to be declared as legal living persons. I must point out, this decision has been stayed by a Lordship's Court. It's pending in another bench, but this is my duty to place that. But it relies upon Shiromani Gurdwara Prabandhak Committee, which said that you can have, in that case, not the Holy Guru Granth Sahib was held to be a juristic person. The point I seek to make is that personhood is no longer limited limited under the Constitution merely to human persons under 21. The point that is to be made is not when animal life and the environment is inalienably connected to us, and therefore we are not whole without it. The protection of that part of life also becomes essential. The avoidance of cruelty to that part of life is also, and today in Nagaraj, as I said, your lordships have recognized that right as to how rights exist in animals not to be prevented cruelly, and use the DPSP and the fundamental duties to read into 28.
Some of the European jurisdictions possibly recognize river, and I think there's one judgment of a New Zealand court, possibly.
Yes, sir. But in fact,
Then the lawmakers should be left with that exercise.
Not-
Why should we
not the question today is,
venture into that territory?
no, we are not asking your lordship to venture into the territory. The question today we are doing is testing whether the law is valid or not.
Yes, that's the only scope of inquiry so far as us are concerned.
Yes. Yes, but that is something about which your lordship is looking at it from the perspective of whether it is legitimate or not. And therefore, that is the test. But in fact, lordship just looks at 671 in that compilation note. which is part of the Guru Granth Sahib judgment. Just have a look at that for a moment. 661 and 671.
अच्छा है, गंगा यमुना juristic person है.
There is a reference to Saman, and it deals with other than human persons. A legal person, para 16, is any subject matter other than a human being to which the law attributes personality. This extension for good and sufficient reasons of the conception of personality beyond the class is one of the most noteworthy feats of legal imagination. Then overly flawed. Para 17, jurisprudence by pattern says it is already been asserted that legal personality is an artificial creation of the law. Legal persons are all entities capable of being right and duty-bearing units. All entities recognized by law as capable of being parties to a legal relationship. Saman said, so far as legal theory is concerned, a person is any being whom the law recognizes as capable of rights and duties. Then Lord 18, and I'll read 18. Analytical and historical jurisprudence describes person. We may therefore define a person for the purpose of jurisprudence as any entity, not necessarily a human being, to which rights or duties may be attributed, as in our case, not rights and duties are attributed. 19. Thus, it is well settled and confirmed by authorities on jurisprudence and courts of various countries that for a bigger thrust of socio-political scientific development, evolution of a fictional personality to be a juristic person became inevitable. This may be any entity, living, inanimate, object, or thing. So any entity, living, inanimate, object, or thing. Now, that's the view your lordships have taken in terms of juristic personality or personhood. And our submission is that we cannot deprive animals and animals to whom various protections have been considered, accepted as part of the constitutional framework, as also under specific legislation, to be out of it. I'm not in this.
Siddharth, I can tell you only one thing,
Yes, ma'am.
at least for myself.
Yes, of course.
Swami, these all surroundings going on, you are not able to know what is your thrust of submission. Because what I'll tell you myself, after Nagaraj, every state consciously made certain amendments,
Yes, ma'am.
which I put to you earlier also.
Mhm.
And if you see section 3 of the Act of 60
Yes.
and section 11,
Mhm.
section 3 and the object also,
Mhm.
it only relates to prevention of cruelty to animals.
Yes, madam.
Okay.
Yes, of
Now
course.
come to section 3.
Yes.
It shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal unnecessary pain or suffering.
Yes, ma'am.
Now, section 11.
Mhm.
Certain amendments have been made under section 11
Mhm.
under the State Act,
Yes, my lord.
and to cover up section 3, they have framed certain rules.
Yes, ma'am.
What preventive measures had to be adopted by respective states in reference to the animals in question for the purpose of their culture and all, to make a balance. And these rules have been framed under the guise of this section
Yes,
3.
yes, ma'am.
But my question to you is that if there is a breach of any rule
Mhm.
prescribed for maintaining and upholding this cruelty to animal in any culture which they organize or their festival, that is not the question to us.
No, that's not the issue.
The question to us is such an amendment made, how this provision is unconstitutional?
Lord, I'll come. Lord,
So our question to you is, if the state legislature is wisdom balancing to continue with their culture also and the safety of animals also, prevention of cruelty also. So according to you, what is the constitutional, you're questioning the validity of this provision in question?
Lord, two things. But 114.
Because Ganga and Jamuna is not going to
No, no,
touch it here.
no, Lord. I was responding to the query
Yes.
as to personal, Lord, since my Lord.
We agree with you on the substance.
Lord, now the only issue, Lord, here is straight away. Our case is that it's a clear case of arbitrariness. You cannot have you cannot have an amendment, so to speak, which will nullify the purpose of the main act. Now,
Now, just
would it
come to
state,
this.
not come straight
Come to
away
this
to,
straight away.
come straight away to Kameshwar Singh, Lord, which is 1952, one is,
No, Mr. Siddharth, we'll come to judgment later.
yes,
You don't go 52.
Yes.
Come hit straight away how this is abuse of discretion with the legislation wisdom exercise.
but I'll straight away show you. Your
Demonstrate first.
Lordship's got this chart.
Unless you give it to us.
Now, Lord, let's look at this. Now, Lord, kindly see,
Demonstrate to us straight away.
come straight away.
Yes, we have a chart.
Now, Lord, come straight
Come
away.
with it first.
Yeah, that's
Siddharth,
that's the one, Lord. That's the one. Now, Lord, kindly just see for your Lordship's convenience, what we've done is, because the other legislations were not there at the time of Nagaraj.
That's correct.
So for convenience, we put not the Regulation Act, which is under question in Nagaraj, in the first column, then the 2017 Act and the rules. Does your Lordship have it?
Yes.
Now, kindly just note, in the definition clause, note is similar. In the earlier act and the current act. Does your Lordship have that?
Yes, we have it.
Now, please come to 3. Now, please keep in mind, 3 casts, as your Lordship has noted, certain duties. Now, see how they have sought to amend 3. Now, 3, Lord, there is an amendment which they make. In the original act, the Tamil Nadu Act, Lord, they had put in certain issues. All of these, every owner of the bulls participating shall, in the event, to the authorities of the Animal Husbandry Department for testing, etc. 2 will be certificate. C will be no performance enhancement drugs. D will be the duties. Now, all of this has not come in section 3 of the original act, the Tamil Nadu Act, but has now been placed in the rules. The safeguards have come now in the rules in the right column. But please see what 3 does in the middle column. And I'm going to read it in its entirety. It shall be the duty of every person having the care or charge of any animal to take all reasonable measures to ensure the well-being of such animal and to prevent the infliction upon such animal of unnecessary pain or suffering. 2, notwithstanding anything contained in subsection 1, conduct of Jallikattu subject to rules and regulations as be framed by the said government shall be permitted. Now, my submission is this. There is now a finding of fact which is untrammeled that Jallikattu per se, sports races involving bulls, keeping with the anatomical nature of the bulls, as my Lord Justice Roy said, they may not have lost weight in the last 8 years. All of that, Lord, is something which has been found and determined by your Lordship. Today they say, we will allow these sports, whether Jallikattu, Kambala, or the race or the exercises, bullock cart races in Maharashtra, and in effect, nullify the first part of the section 3. And how do we do it? We bring in these rules, which could not have even been before the president because the rules came later. So these rules are safeguards, which they see, safeguards that they bring later. Now, Lord, please then come to, on the 4th page, section 11 is there. Now, in section 11, Lord, they have, those were the exceptions, Lord, section 11. As to section 11.3, what will not be done? Then, Lord, there's 22. And section 11, kindly note overleaf, they will say in italics, F has been added. And I'm just using the Jallikattu example, all others are similar. The conduct of Jallikattu with a view to follow and promote tradition and culture and ensure preservation of native breeds of bulls, as also their safety, security, and well-being. I put it to your Lordship, Lord. The exceptions were specific in the central legislation. And what are they illustrated? Look at B. Destruction of stray dogs in lethal chambers. Extermination of any animal under the authority of law for the time being in force. Not such as the Wildlife Act when you want to cull an animal. Any matter dealt with in Chapter 4, which is scientific testing. E. The commission or omission of any act in the course of destruction of the preparation as food for mankind, unless destruction or preparation was accompanied by the infliction of unnecessary pain or suffering. So proportionality and necessity, yet you bring in a simple thing, conduct a Jallikattu with a view to follow and promote tradition and culture, ensure preservation of native breeds of bulls, as well as their safety, security, and well-being. Now the question to be asked is,
And also the experience on animals
how are you going to
is not permissible.
compare, you say there are bulls which do racing, you say there are bulls which are meant as draught animals and for breeding. What is this exception that you have sought to create?
One thing, always the legislature, they understood and recognized the life of a human being, the life of an animal differently.
Yes.
Say, for example, whether mercy killing is permissible or in the case of human beings.
But now in terms of the common cause, your lordship has allowed it to be done. And I must also point out, since your lordship has raised a very important issue, not under the 2002 medical rules, not medical ethics rules, under regulations 6.7, a person who is in a certain brain dead state, vegetative state, a committee of doctors, even under the subordinate legislation, can actually, in effect, take off life support. Not that's regulation 6.7.
But then
specifically
come to 13.
yes, but 13.
13 and 14, in that sense, they are relevant.
But
You come
13
to 13,
yes, of course.
see, if
14, yes, but 13.
13 and 14.
Yes, of course not.
14, it permits experiments on animals.
Yes, of course it does.
That is permissible.
And not, please see the purpose. Please see the purpose for a moment.
We are only saying that the legislature, how they view it. So 14 is there and 13 also. The only thing is that if it would be cruel to keep the animal alive, if that is the belief, then of course you can.
My lord, I must tell your lordship, even in the case of human beings, your lordship has permitted regulated clinical testing on human beings. So human trials are permissible. It's not that they're
See
not.
the difference between these two, 13 and 14.
But I completely understand.
When it comes to the case of human beings and when it comes to the case of the animals,
Yes.
so the legislature thought it very carefully and put them in different pedestals.
Lord, if I may say so, Lord, so far as 13 is concerned, please also then consider 12. 12 says cruelty not to be permitted, Lord, it provides for specific practices. Now, if your lordship says, if this is the swan song of this legislation, then my respectful submission will be the exception carved out for sports is a matter of entertainment. 13 is to prevent further pain and suffering to an already injured animal. Not the similar example in the case of human beings, though it's much more narrower, because there the considerations become somewhat different. Are, as I said, regulation 6.7 and the common cause judgment, whereby your lordship allowed for people to be taken off life support through the living will process. Having said that,
13 and
14, Lord, also consider this 14. 14 says, nothing contained in this act shall render unlawful the performance of experiments on animals for the purpose of advancement by new discovery of physiological knowledge or of knowledge which will be useful for saving or for prolonging life or alleviating suffering or for combating any disease. Now see, whether of human beings, animals or plants, the doctrine of necessity. So Lord, all I'm saying is, this is the doctrine of necessity, which is a known carved out exception. We are dealing with a non-essential thing.
distinction has been made.
Lord, if it was an
So 14, if it is for the purpose of advancement of or discovery of or for the welfare of the human beings, then it is permissible.
or animals, not or animals, or
14,
animals or
14.
plants, or animals or plants. Please see that it says all three. No? It says all three. It says for combating any disease, whether of human beings, animals, or plants. So the point I seek to make is not there is the doctrine and the principle of necessity. So far as necessity is a recognized statutory exception that has been made. And that exception cannot then be treated at par, and that's where the arbitrariness will come in. It cannot be treated at par or as a sport for the purpose of human joy or fun or entertainment. We can't not, and that's where I would say, Lord, that exception cannot be applied to create such exceptions of the like that are sought to be done.
All these were put when you actually made an attempt to say that Article 21 is available.
Yes, Lord.
Initially, you attempted to canvass the position that Article 21 is available to animals also. That is why we put all these.
Yes, of course. Yes, of course. But I've sought to argue that and place it before your lordship for your lordship's consideration. Now, Lord, I'll just come to manifest arbitrariness after that. But if your lordship just sees, as my Lord Justice Rastogi put it to me, Lord, please see the exceptions that are contained, Lord. All of this is really an exercise which is to replicate the TNRG Act through another legislative mechanism. That is the sum total of it. Now, Lord, if I may just take your lordship now to the argument that we were seeking to make on arbitrariness, not because that is one aspect which I will have to place at some length. And Lord, multiple decisions, but I'll just place Shaira Banum, Lord, and kindly just see that's at volume 5, page 887.
This is
Volume 3, page 887.
That is why they define animals other than human beings without any code laws. That is why he defined the sex.
Lord, I will also place before your lordship on before Lord we come to the next part, certain foreign judgments. Lord, there's the monkey case from Ecuador, and there is a quote from in relation to chimpanzees from Argentina. Lord, those we have the relevant paras, but which recognize their rights, because your lordship on the last
What
occasion.
are on the simian species?
But it's not so far, those are the ones we found. There are others, but the translations were not easily available. So we are not able to decipher what is the ratio of the decision. Lord. But we'll place those, Lord. One is from Ecuador, and one is Constitutional Court of Ecuador, and one is from Lord, the Court of Guarantees in Argentina. Now, Lord, the point that I have been trying to canvass to your lordships is this. When a legislation talks of cruelty and prevention of cruelty, and the amending acts perpetuate what we state as cruelty, then the two cannot go together. I will just leave with your lordship the one line from Kameshwar Singh, Lord, which is,
Kindly repeat the proposition.
well, I'll just tell your lordship straight away. When the legislation and the legislative entry talks of prevention and protection against cruelty, we cannot have amending acts which perpetuate cruelty. In this context, kindly just make a note of one para in Kameshwar Singh Lord. There were three judges who said the same thing, but there is a very interesting sentence, Lord, in this regard, because one of the issues that was raised was on the colorable nature of the legislations. This was in the context of not the Land Reforms Act, and as your Lordship would have noted, not interestingly, none other than Dr. Ambedkar had argued matter on some of the cases.
UP Zamindari Association.
Yes, not all the Zamindari Acts and Land Bihar Land and other land reform acts. I'm not here. The issue was in relation to the entry of entry 36 of acquisition or requisition of property lot, except for the purposes of list 3 entry 42, and list 3 entry 42 was compensation which could be given for properties acquired, etc. And whether the power was validly exercised. Now, there is not just a very important line which I will place for 2 paras, if I may. It's a para 78. And 80, not one sentence. 78 said, it is by no means easy to impute a dishonest motive to the legislature of a state and hold that it acted malified and maliciously in passing the Bihar Land Reforms Act, or that it perpetrated a fraud on the Constitution by enacting this law. It may be that some of the provisions of the Act may operate harshly on certain persons or a few of the zamindars, and may be bad if they are in excess of the legislative power of the legislature. But from that circumstances does not follow that the whole enactment is a fraud on the Constitution. From the premises that the estates of half a dozen zamindars may be expropriated without payment, one cannot jump to the conclusion that the whole of the enactment is a fraud, or that all provisions as to payment of compensation are illusory. 79. Section 23F, however, in my opinion, is a colorable piece of legislation. It has been enacted under power conferred by legislative entry 42 of list 3. It is well directed, settled that Parliament with limited powers cannot do indirectly what it cannot do directly. In section para 18, the provision herein impeached has not been arrived at by laying down any principle of paying compensation, but in truth is designed to deprive a number of people of their property without payment of compensation. The state legislatures is authorized to pass an act in the interest of persons deprived of property under entry 42. They could not be permitted under that power to pass a law that operates to the detriment of those persons, and the object of which provision is to deprive them of the compensation to a certain extent. Then, my lord, the issue was really this, that you cannot use an entry to nullify the purpose of that entry. Our submission today is, and there are other passages in the Honorable other Judges' Lord views at paras, specific not paras. (159) and 176, and all of them in essence say that we can't, under guise of granting compensation, the computation of compensation is what is permitted by the entry. Under that guise, you can't do away with compensation completely. So we can't have a situation where we nullify the provisions of the legislative purpose behind the PC Act, and therefore our solution is that these 3 legislations are a colorable piece of legislation. In this context, Lord, kindly just have a look at one more decision, which I would like to place, which is serial number 32 at volume 5, page 1969, Constitution Bench Judgment.
What is that?
Lord, this is the Ramanlal Keshalal Soni's case, and this is in the context of that Gujarat Panchayats Act. Lord, here there are 2 parts to it.
We call it implosive construction.
Yes, Lord, I would say implosive, not construction, implosive destruction in the construction. See page 1969.
argument is that whatever the provision of the law is there, you are amending it to defeat that very
Yes,
purpose.
but that is not one of the.
That is your argument.
That is one of the arguments. The second will be to overcome Nagaraj, and I'll just place that part after this.
Overcome Nagaraj doesn't have, doesn't the legislature have a
Lord, it does, if it does away with the basis of the judgment.
jurisdiction by a legislative amendment to overcome the effect of any judgment?
It can, but the contours of that has also been described, Lord. Your lordships have made it clear.
Extreme example is that Madan Mohan Patel.
Yes. Yes, ma'am. Yes, ma'am. Now, Lord, if I may just place this one, Lord, for a moment. Please just come to 1991. I'm not just seeing. That's all. Kindly just have a look at 1991, para 33. We then come to the writ petitions. As mentioned by us earlier, the Gujarat Panchayats Act was amended during the pendency of the appeal in an effort to nullify the effect of the judgment of the Gujarat High Court. First, the government promulgated an ordinance. Next, the legislature enacted the amending act. By section 2 of the amending act, original section 11(1), which declared that Gram Panchayats, Taluk Panchayats, etc., shall constitute Panchayat organization of the state, was omitted. Original 11(2), which provided for the control of state government over Panchayats directly or through their officers, was made. It is extremely difficult to understand the omission of old 11(1). The whole object of the Gujarat Panchayats Act is democratic decentralization of power and the consequent reorganization of administration of local government. The object is to decentralize and reorganize, so it was thought that Gram Panchayats, Nagar Panchayats, Taluk Panchayats, District Panchayats should constitute the Panchayat organization of the state of Gujarat. The object of the act is still the same, yet 11(1) has been omitted. Does it mean that there is a disbandment of organization? According to the statements and objects, the amendments were necessitated to get over the judgment of the Gujarat High Court that Panchayat service is a state service. But surely that can't be a reason to go against the object of the Principal Act and to abandon the constitution of a state Panchayat organization. No wonder it was described as an act of cutting the nose to spite the face. You mentioned here that the section 2 was deemed to have come into force on February 24 when the original act was in force. Then not para 51. 1997. Now in 1978, before the amending act was passed, thanks to the provisions of the Principal Act of 1961, the ex-municipal employees who have been allocated to the Gram Panchayat service as secretaries, officers and servants of the Gram and Nagar Panchayats had achieved the status of government servants. Their status as government servants could not be extinguished so long as the posts were not abolished and services were not terminated in accordance with the provisions of 311 of the Constitution. Nor was it permissible to single them out for differential treatment. That would offend Article 14. An attempt was made to justify the purported differentiation on the basis of history and ancestry, as it were. It is stated that Talatis and Kotwals who became secretaries, officers, and servants were government servants even to start with, while municipal employees became secretaries, officers, and servants were not. Each carried the mark or brand of his origin, and a classification on the basis of source from where they came to service claim was not permissible. We are clear it is not. Once they joined the common stream of service to perform same duties, clearly not permissible to make any classification. Such a classification would be unreasonable and entirely irrelevant to the object sought to be achieved. It is to navigate around these two obstacles of 311 and 14 that amending act is sought to be made retrospective to bring about an artificial situation in the erstwhile municipal employees never became. Can a law be made to destroy today's accrued constitutional rights by artificially reverting to a situation which existed 17 years ago? No. Legislation is pure and simple self-deceptive if we may use such a expression with reference to legislature-made law, the legislature is undoubtedly competent to legislate with a retrospective effect to take away or impair any vested right acquired under existing laws. But since the laws are made under a written constitution and have to conform to the do's and don'ts of the constitution, neither prospective nor respective laws can be made so as to contravene fundamental rights. The law must satisfy the requirements of constitution parties taking into account the accrued or acquired rights. The law cannot say 20 years ago parties had no rights, therefore requirements of constitution will be satisfied if it is dated back 20 years. Now, Lord, based on that, at the last part of that page, Lord, last 8 lines of that page, we are therefore firmly of the view that Gujarat Acts is unconstitutional as a defense 311 and 14 is arbitrary unreasonable. We have considered the question whether any provision of the Panchayat's Third Amendment Act may be salvaged. We are afraid provisions are so intertwined that it will be impossible to consider any life-saving surgery. Lord, this is the point, Lord, that we were seeking to make. I would also like your Lordship just to have a look at the decision in same volume at page 1855. Now, the issue, Lord, is to what extent can you nullify a judgment? Please come to para 149 at 1943. And please come to below placetum C, 149 at 1943.
Para 149.
149 at 1943. Please just see that, Lord, 149, about the, just below placetum C, the constitutional principle. The constitutional principle that the legislature can render judicial decision ineffective by enacting validated law when its legislative field fundamentally altering or changing its character retrospectively has no application where a judicial decision has been rendered by recording a finding of fact. Under the pretense of power, the legislature cannot neutralize the effect of the judgment given after ascertainment of fact by means of evidence materials placed by the parties to the dispute. A decision which disposes of the matter by giving finding upon the fact is not open to change by legislature. A final judgment once renders operates and remains in force until altered by the court in appropriate proceeding. Our submission is Nagaraj in paras 15 to 21, 34, 40 to 44, 73 and 74 has given findings of fact. The nature of the activity, the nature of the cruelty, the nature of the sport, and why it is unjustified and contrary to the purpose of the act. In any case, but the findings of fact on the animals which are sought to be raised are clear, which have not been trammeled. Then, Lord, para 150. The 2006 Amendment Act plainly seeks to nullify the judgment of this court, which is constitutionally impermissible. Moreover, it is not disputed by Kerala that the 2006 Amendment Act is not a validation enactment. Since the impugned act is not a validating law, it is not required to inquire whether in making validation, legislature has removed the defect which the court has found in existing law. 2006 Act in its application and effect on the Mulla Pariyar Dam is a legislation other than the substantially legislative, as it is aimed at nullifying the prior and authoritative decision of this court. The nub of infringement consists in the Kerala legislature revising the final judgment of this court in utter disregard of the constitutional principle that the revision of such final judgment must remain exclusively within the discretion of this court. And that is the principle, Lord. There are numerous other judgments which can be cited, Lord. And this issue regarding finding of fact is again reiterated in para 157 at page 1945. The question whether or not the legislature has usurped the judicial power or enacted a law in breach of separation of powers principle would depend on the facts of each case after considering the real effect of a law on a judgment or judicial proceeding. One of the tests for determining whether a judgment is nullified is to see whether the law and judgment are inconsistent and irreconcilable so that both cannot stand together. In what we have already discussed, it is abundantly clear that on the one hand, there is the finding of fact determined by this court on hearing the parties on the basis of evidence materials placed on record in the judgment of this court in the Mulla Pariyar Environmental Protection Forum. On the other hand, the 2006 Amendment Act has declared the dam being an endangered one, fixed the water level. If the judgment of this court in Mulla Pariyar and the 2006 amendment are placed side by side insofar as safety of the dam for raising water level is concerned, it is obvious that the judgment of this court and the law enacted by Kerala State Legislature cannot stand together and they are irreconcilable and inconsistent. The impugned law is the classic case of nullification of a judgment simpliciter. As in the judgment of this court, the question of safety of dam was determined on the basis of materials placed before it and not on the interpretation of any existing law. And there was no occasion for the legislature to amend the law by altering the basis on which the judgment was founded. When the impugned judgment is not a validation law, there is no question of legislature removing the defect, as the court has not found any vice in the existing law and declared such law to be bad. So that is the principle. Not Indra Sani reiterates the same principle. I'll give your lordship the paras. I don't want to reiterate. I'm
Only the multiplying because this is the
But I'm not going to multiply. I'm not on Shaira. Lord Shaira Banu is the case on manifest arbitrariness. I'll just give your lordship the paragraphs, which my lord may just note. If my lord permits, Lord, I could have gone through them, but I would not like to take too much time. Lord, that's 2017, 9 SCC, page 1. Now, reason we are concerned with Shaira Banu and the paras will be 72 onwards. There are two sets of paras, Lord, in Shaira Banu. If I may just point out, Lord, there is a discussion on how manifest arbitrariness came to be an accepted concept, Lord, 72 onwards. And then, Lord, there are a number of paras criticizing the McDowell case and why it didn't consider binding precedents. So I won't necessarily want to trouble your lordship on that. But kindly just note some of the crucial paras. Lord, begin, I'm sorry, with 67. 67 at page 961 of the report. To 71. To 71. Then please look at 77 to 87, and I'll place 87 at page 977 of the report. In fact, Lord, just see para 85 for a moment, page 1975, because I'll answer another of your lordship's questions. Para 85 at 975. May I paste that, Lord, for a moment? A question had been put to me, Lord, should we sit over parliamentary wisdom? And the answer lies here. The third reason given is that courts cannot sit in judgment over parliamentary wisdom. Our law reports are replete with instance after instance where parliamentary wisdom is successfully settled not by the court because such laws did not pass muster on account of them being unreasonable, which is referred to in Om Kumar. We must never forget the admonition given by Khanna in State of Punjab versus Khanchand. He said, it would be wrong to assume that there is an element of judicial arrogance in the act of courts in striking down an enactment, the constitution is assigned to courts the function of determining as to whether laws made by legislature are in conformity with the provisions of the constitution. In adjudicating the constitutional validity of statute, courts discharge an obligation which has been imposed upon them by the constitution. Courts would be shirking in their responsibility if they hesitate to declare the provisions of the statute to be unconstitutional, even though those provisions are found to be violative of articles of the Constitution. But I won't read the rest. Please come to 87 at page 977. The thread of reasonableness runs through the entire fundamental rights chapter. What is manifestly arbitrary is obviously unreasonable, and being contrary to the rule of law would violate 14. Further, there is an apparent contradiction in the three-judge bench in McDowell when it said that a constitutional challenge can succeed on the ground that a law is disproportionate, excessive, or unreasonable. Yet such challenge would fail on the very ground of the law being unreasonable, unnecessary, or unwarranted. The arbitrary doctrine, when applied to legislation, obviously would not involve the latter challenge, but would involve the law being disproportionate, excessive, or otherwise being manifestly unreasonable. All the aforesaid grounds, therefore, do not seek to differentiate between state action in various forms, all of which are interdicted. They fall foul of the fundamental rights guaranteed to persons and citizens in Chapter 3. Then, Lord, please come to 95 for a moment. 95 at page 981 refers to national resources allocation and says that McDowell is not an authority. That legislation can never be struck down as being arbitrary. Relies on Ajay Hasya. Please come straight away to para number. But just my learned friend wants me to place one more aspect, Lord, of 95, Lord, at 981 bottom, last line. A constitutional infirmity is found in Article 14 itself when legislation is manifestly arbitrary. That is when it is not fair, not reasonable, discriminatory, not transparent, capricious, biased with favoritism or nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. Positively speaking, it should conform to norms which are rational, informed with reason, and guided by public interest. 96 will quote with Subramanian Swami.
Subject, does it come within the ambit of these principles?
Sorry, Lord?
The dispute we are dealing
Yes,
with,
Lord.
do they come within the?
Indeed, my Lord, and I'll tell your Lordship why. But why is this legislation arbitrary or manifestly arbitrary is something which your Lordship has to consider.
So far as nullifying the effect of judgment, you've understood your argument.
That's one. Lord, the second argument is, but where is the necessity? How do you distinguish between two categories of animals to say bulls in races are distinct than bulls in agriculture, or as pack or load carrying animals, draft animals? Now, Lord, these distinctions. And then the distinction also lies that whereas for the purpose of agriculture, whereas for the purpose of science, whereas for the purpose of load carrying, you have said that these animals are allowed to do so by virtue of the physiology and their nature, and also the fact that that is an accepted part of the activity which they can do even under the Act. However, 311 applies there and they have to be protected, and that's the reason also for the subordinate legislation, the draught animals rules, the pack animals rules, making them walk on foot rules, as also the fact not performing animals rules where they're exempted. But here you take them out of you nullify the effect of the 2011 notification, you take them out of the whole, but you take them out of the application of the Act completely. So you're really saying by this that they are going to be taken out of the protective cover of that legislation. Now, I'm not with respect, that is the arbitrariness, because there is no basis to do that, no rational basis. And the absence of necessity makes it totally vulnerable on the ground of arbitrariness.
Yes.
Now, Lord, the last aspect will really be And there are other decisions which one can place. Kindly just make a note of Lord, para 100 and 101 of that judgment. Just make a note of the para. I'm not going to read them.
Shaira Manu.
Yes, Lord. 100, 101, 102. Our case, Lord, has been that when you look at, and that is the reason, Lord, I read to your Lordship that Kameshwar Singh's principle, when we look at the substance of the act, because we really like to understand what is the basis of the act, the pith and substance, where does it fall? That's not just to look at it from the purpose of what does it seek or achieve to do. It seeks or achieves cruelty, though it seeks to come under the entry of prevention of cruelty. And that was the purpose, Lord. When I touched on legislative competence, it was not so much legislative competence, it was the colorable nature of legislation, which I should have clarified, and I've done that. Now, Lord, the only thing that will remain to be addressed, Lord, which if your Lordships give me 10 minutes after lunch, will be on the presidential assent. Just 10 minutes, and I'm 2:15, I'll be done.
But can you indicate what would you argue on
But,
that?
Lord, I will begin by pointing out, Lord, what is the contours of presidential assent, because they are now trying to fit this into two slots. On the one hand, their slot is that it will come under list 2. List 2, it's apparent it doesn't come. Apart from the Nagaraj lot, it's apparent on the reading of list 2. And that's the pith and substance 2. Then, Lord, there that it comes under 254(2), because once they say it has got the assent of the president, therefore the law will prevail. Our point to be made is 254(2). Our point is the act of giving assent or seeking assent has a certain amount, has a connotation to it. Assent is not a mere idle formality. It is subject to judicial review and the contours of judicial review on that.
Oh.
There are no pleadings, there are no pleadings in any writ petition with
Not the-
regard to 254.
And I'll-
Siddharth, you have certain other lawyers also to take over the charge. They will take care.
As not, if your Lordship give me 10 minutes, fine, otherwise I'll just 10 minutes. 2:15, Lord.
What? We can sit for 5-7 minutes more, complete it.
If your Lordship.
So that,
I'll finish, Lord, if your Lordship give me now, I know,
So that, you can start.
I don't believe, Lord, let somebody start afresh. Fresh minds and fresh thoughts will probably give greater clarity than I can. Now, Lord, the argument on this has been twofold.
You are questioning the decision-making process in giving assent.
Yes, Lord, and the fact.
Have you taken as a ground in any of the writ petitions?
Well, I'll just tell your Lordship what is exactly pleaded. I'll place that in a moment. My learned friend will just pull out the grounds that's taken on this aspect. But till there, that's done, Lord, two things. Your Lordship has seen the language of 254(2). I don't need to read it. The question that your Lordship will want to consider is, have any of the three states placed any material before this court to show A, how there is a conflict between the 1960 Act, if any, and the Amendment Acts? And was this brought to the notice of the President? B, if this is not done, if the aspect of removal of cruelty has come through the rules and not the principal act, then clearly it could not have been placed before the president, because all they've done in the principal act, say our amending acts, are to say Jallikattu, Kambala, races. All of the issues regarding cruelty and its safeguards come in the rules. They're not in the act, either of the three legislations. Our submission is, C, this having not been done and no material placed before your Lordships, there is no question of protection under Article 254(2). The only document we have come across is Annexure A11, Maharashtra, page 38, Maharashtra compilation, a document dated 26 July 2017, which refers to two copies of the wills. Nothing else is done.
Is there any decision precedent
Yes,
where the manner of giving
Yes.
assent
yes,
has been questioned?
not enough, enough and more. Not enough and more. Kindly have a look at 2002 8 SCC 182.
Anyway, you just give us the
But
citation.
I'll give your lordship the two decisions. There will be two decisions which your lordship would like to look at. Both constitution benches. Please note 1985 3 SCC 661. Gram Panchayat of village Jamalpur versus Malvinder Singh. Para 18. Para 12, I'm sorry, para 12, my mistake. Para 12. And Lord, here, there is a specific line at page 669 of the report that judgment of the High Court shows that hearing was adjourned to enable the state government to place material before the court showing the purpose for which the act was forwarded to consent, and the reasons were not given. And assent of
Should
president.
it not be pleaded by you?
But I'll just pull out. But there is a pleading.
You have a definite key.
But I'll just give your lordship the exact plead note. I'll place that. I'll give it that to your lordship. Just make a note of the other decision note, and I'll close with that. 2002 8 SCC 182. Again, a constitution bench by judges. Kindly just note paras 1, 3, 8, 1, 14, 1, 3, 8, 14, 16, 20, 27 and 28. And what para 28 specifically deals with the High Court calling for the file and seeing what purpose assent was sought. Para 28 is specific. And paras 65, 73, and not 65 and 73 and 74 are in the supplemental judgment. Lord, I will, if your lordship permits me, just place this one sentence for your lordship from para 20. It is true that the President's attempt has notified nowhere mentions that assent was obtained for repugnancy between state legislation and government law. But from this, it cannot also be inferred that the President has given assent. All earlier laws on the subject would not prevail, as discussed above. Before grant of assent, considerations of reason for having such law is necessary, and consideration would mean consideration of the proposal made by state for the law enacted despite it being repugnant to the earlier law made by Parliament on the same subject. If the proposal made by state is limited for repugnancy of state law and law laws, then it cannot be said that the assent was granted for repugnancy between the state law and other laws for which no assent was sought. So, Lord, that is the principle in para 20. I'll conclude in that, and I'll find that clause in our lordship. I'm most grateful for your lordship's kind consideration. Grateful.
is the pleading that on residential assent in writ petition 23 ground F, there's a reference to the residential assent not protecting the act.
Petition 20,
Writ petition number 23, the lead matter,
that's right.
ground F,
Ground.
page 54.
Lead matter is 24, 23.
Reading as to,
Residential assent is not saving the act from repugnance. There's a pleading.
yes,
Yes, Manoj, I appear for the petitioner in writ petition civil 1011 of 2017. My challenge is confined to the Tamil Nadu Act
1 minute, 10.
1011 of 2017. The respondent is the state of Tamil Nadu. My challenge is only to the Tamil Nadu Act. Now, responding to what Justice Rastogi had mentioned a short while ago, I wanted to just indicate what my points and the thrust, to use your lordship's expression, what's the thrust of my submissions going to be? I'll state that first. I'll also like to indicate what I am not going to canvass, so that the scope is narrowed to whatever extent. And thereafter, I'll indicate as to how I plan to proceed. Now, my thrust is 3 or 4 points. It falls truly under this expression which was used and on which your lordships have framed a question, colorable. So the exercise, the Tamil Nadu Act amending the Prevention of Cruelty to Act is a colorable exercise, and I'll just list the points. The first point is it completely seeks to destroy or is contrary to the well-entrenched principle of separation of powers. This is my first point. Second, the issues regarding cruelty, brutality, as far as Jallikattu and the racing, etc. is concerned, have attained finality. And a very important principle repeatedly laid down by this court is that once matters attain finality and certainty, the credibility of this institution itself is founded on the fact that there is a certain conclusiveness to a final order which is passed. The third limb of the submission is going to be that we have now an emerging doctrine called, it comes under 2 names in international law. It's been adopted by this court. It's called non-retrogression or the progressive realization of rights. Under our constitution, which has been held to be a living document which responds to the changing times, we have progressive realization of rights. Rights move forward. They don't go back and shrink. So that's going to be a third limb. The fourth limb of our submissions is going to be that there are findings of fact, which I will take you to in the judgment in Nagaraj, but keep that aside. There are subsequent facts which we have placed on the record in the form of, on affidavit, in the form of site inspection reports as to what is happening with regard to Jallikattu. And what you will find is that there is no difference. And now I am making the point. The point is our science and understanding regarding sentient creatures. So I'm not talking about trees. I'm not talking about mosquitoes. I'm talking about sentient creatures that has advanced since 2014. And if anything, it should reinforce, or that will be our effort to persuade you that it reinforces the directions which Nagaraj has already laid out and which Nagaraj already points to. Finally, this was an interesting question which was posed in the first day. And the question was, in theory, can the Prevention of Cruelty to Act itself be fully repealed, etc.? What happens then, 1960? Or number 2, supposing, and I must answer it, so I'll answer it right away and then I'll elaborate on it. Or number 2, supposing Parliament brought this act so that, we don't have all those problems regarding legislative competence, etc. We must consider those aspects. So I'll give you my answer first and then I'll try and justify. My respectful submission is that apart from progressive realization and non-retrogression, let us assume that Parliament first and foremost repeals this act. Point 1, it's just repealed. 1960 Act is taken away. What happens then? My submission will be that having regard, and I'm of course in my theoretical situation saying that it is not reenacted in some form, correct? We are just theoretically not reenacted. My submission will be the constitutional guarantees, 1, the principles articulated by this court in Nagaraj and other judgments is sufficient to nevertheless protect animals and bulls in particular from Jallikattu? That's going to be my answer. So it will not make a difference whether Parliament can't bring it down. That's another separate issue. But even if this is repealed, we now have sufficient traction on the principles laid down by this court on constitutional principles and on the evolution of the law and our understanding and sensitivity as far as sentient creatures is concerned, that even if this act goes, this type of a practice would meet an embargo if we are correct. Then I would like to respectfully submit that then your lordship correctly put to me. So 21, let me just, there may be other facets to 21, but I'm just mentioning my facet. Mine is a very limited facet to 21. My first facet to 21 is that human beings die in Jallikattu, and we're going to place that on the record. And they suffer injuries. Number 2. So there is clearly direct impact on 21. That's my first submission. My second submission is going to be, we understand that there's a certain penumbra of rights which have been developed by this court under Article 21. For example, the right to a wholesome environment. I'm just giving it. There's no express articulation, but it gradually came up through judgments of this court. And now in July this year, 4 decades after this court articulated, or 3 decades later, the United Nations General Assembly has also now passed a resolution, unanimous resolution of the United Nations General Assembly, saying that everyone has a right to life, a right to a healthful environment under the aspect of right to life under 21. So the point over here is, the first submission is people are injured and die, 21. And the second element is that in this penumbra, your lordships have read various rights. So it is, so now let me just tell you straight away what I am not canvassing. I am not canvassing personhood for my purposes. There may be other counsel, etc. So I'm not giving it up, etc. But at least I will not detain your lordships on that line of argument. So I'm not suggesting that 21 is something which is that the bulls, etc. have an Article 21 fundamental right. Indeed, I am content with Nagaraj. And the Nagaraj judgment and what hasn't been placed, or at least my understanding is that it hasn't yet been placed, the very all-important review judgment of this court in Nagaraj as well, which I'm going to place before you. So that will give a complete idea. But what's the point? The point over here, therefore, is that as far as 21 is concerned, I have mentioned my point. 14 applies in different aspects. 14 will apply, Mr. Luthra mentioned it to the court, and that's the classical test. That look, if you have bulls as a species, then where is the question of distinguishing between? It's an artificial distinction with no realistic object or rational object, or a rational connection to the object sought to be achieved, which is you're excluding certain types of bulls for the purpose of protection of the Prevention of Cruelty Act, etc. That is the classic classification test. But I'm just flagging, because just now I'm only flagging the issue. There's one very important principle this court has laid down, an aspect of Article 14, and I'm going to confine myself mostly to Constitution bench judgments, except in 1 or 2 cases. In 2 Constitution benches, your lordships have held that even, I'm sorry.
You're appearing for
for the writ petitioner.
That is Animal Welfare Board.
No, it's the People for Ethical Treatment of Animals, PETA, India versus State of Tamil Nadu, writ petition 1011 of 2017.
It's a body association.
Yes, and it's a registered society. I'm obliged. So, sorry. So, allow me to just flag the issue.
Yeah.
Let me just state the issue. The issue, I'm only on Article 14 now. On Article 14, this court has laid down that even before we come to the classification test, if your objective is per se illegal or discriminatory, I'm using the language of this court. Under Article 14, if your object is illegal or discriminatory, it will be struck down. The action, whether legislation or executive, will be struck down before we even come to the classification test. And I am therefore, apart from the separation of power point, etc., finality of judgments, etc., going to try and urge and persuade your lordships that this object itself, having regard to the development of the law, may not be a valid legal object, and the object itself is discriminatory. So this is going to be the broad heads of submissions, then I'll develop them quickly. So I have also mentioned to the court that as far as now, I'm just 2 more points. First question, and then I'll get straight into the judgments. The first point I want to mention is, that for my purposes, Nagaraj in its operative directions urges Parliament and says perhaps the time has now come to elevate animal rights to a constitutional status. Your Lordship may recall that particular direction, which is given by our court. So I am content with that, in the sense that I am content that it is not housed in the Constitution as such, as an animal right. Of course, there are directive principles, etc., compassion, all that is a separate issue. But I am content with saying that, look, this is the state at which we are, and Parliament hasn't brought in a subsequent act. So I am not going to read into the statute, into the constitutional provisions, any animal right as such. That does not mean, however, that there are certain now, I mean, I'm using the word, I think, a little overbroad, but I'm fortified by your Lordship's judgment. There are 5 sets of freedoms, for example, which have been recognized more or less universally in the context of animals. 5 freedoms, nothing to do with the Prevention of Cruelty Act. These freedoms have been recognized globally in the science, in the literature, and it's not appropriate for me to use the word the civilized world. That's not a correct expression. But with the march of civilization across the world, these 5 rights have been recognized. And I will place those before you because they've been recognized and enumerated in Nagaraj itself. So this is one particular element. And the final point I want to make is on legislative competence. Speaking for myself, I believe that it falls under entry 17 list 3. Correct. So there will be others who may canvass and say that, look, this is that the state has no legislation. Whether they can't do it for a variety of other reasons, but I am not going to press so that your Lordships know at least the scope of my submission. So these are my submissions. Now what I plan to do is 2 things. I want to take you through certain paragraphs from Nagaraj's judgment first. And then I want to take you through the review judgment, which has not yet been placed before the court. And I want your Lordships to keep one thing in mind. The judgment in Nagaraj's case turns on facts. This is the most important submission. It goes on facts. There's a determination and a conclusive determination, according to us, on a factual foundation. Now, this has important repercussions on 2 elements. Everything, volume 7.
Now that you've given up this Article 21 first.
I am not, Manoj, giving it up. There will be others. I am not going to address your Lordships. I believe I am assisting the court, but I won't assist your Lordships on that.
So
Yeah.
we have to proceed on the basis of your assumption.
Yes, yes.
Which is that you are not really proceeding the argument of personhood. And
Yeah, I'm not going to take up your time at all on that.
if that is so,
Yeah.
before you go to
Right,
Nagaraj,
right,
I'd like
right.
to ask you.
Right.
See, the judgment is based on a framework.
Yeah,
That framework was the 2009 Act.
yeah, quite right.
And the 2009 Act was
Yeah.
struck down as being repugnant.
Inter alia. But you're absolutely right. The answer is yes, it was struck down as repugnant, but there were a whole host of other findings on facts which were also entered.
We were just asking you to just imagine
Yeah,
for a moment
yeah,
that the court had before it
yeah,
this act
yes,
at the time.
yes.
That is the act
17 Act.
which you say
Correct.
falls under list 3
Right.
and it has
Right.
a legislative power.
That's a good approach. Yeah. Yeah.
So because that's how we can.
No, absolutely right.
So if that were the statutory framework.
Yeah.
Would the decision have been rendered, number one, on the
Yeah.
same line?
It would have been, the conclusion would have been the same, but obviously they would have struck down this particular thing, and the repugnancy and legislative conflicts argument would not be there. That would not be there. That repugnancy argument and conclusion, it's one of the several conclusions which they reach, that wouldn't be there. I agree with you. I think that's a good way of testing it.
But then what would be the basis for the court to approach the issue then?
Yeah, but no, I think the court, what your Lordship is putting to me is that forget the 2009 Act. They didn't go through the state legislature did not go through a separate act route.
Yeah.
It went instead through an amendment of the Parent Act route, which is exactly what they've done here.
Exactly.
The question being put to me is, would the outcome have been different? On my understanding of this judgment, the outcome would not have been different, save and except one aspect. That with regard to the repugnancy argument, there would have been no discussion and there would have been no conclusion because that would not have arisen.
No 21 argument.
The
No Article 21 also, because we have.
No, 21 would have been there because the court finds that people have been killed in Nagraj. That hasn't been read to the court. The court finds that people are being injured on the ground, and my 2022 report also says the same thing. Every year, people are dying over there. So there's a clear 21 issue, but not the personhood one. That I'm not going to say. It does. I don't read Nagraj to say to elevate it to personhood. The court is very disciplined in my respectful submission, and correctly so. But it reaches, yes, I'm sorry.
Oh. So far as this Jallikattu and
Yeah,
there's such certain death has taken place,
yeah,
but we are examining the prevention of cruelty to animals.
of course you are.
If anybody die in the Jallikattu
Right.
function,
Right.
which is not the question before us.
No, I'm just, Your Lordship, that's not the question is, the issue is, parties have come under 14, which we've explained. Parties have also come under 21. Because the embargo, which was placed by this court in its judgment in Nagraj, and which is reaffirmed, because I'm going to take you to the review judgment as well, and reaffirmed in the review decision, comes to the conclusion that this particular practice is something which must be stopped. One, because it's in violation of the Prevention of Cruelty Act, because it impinges and visits huge amount of cruelty and brutality on the animals themselves. And second, it also impinges and impacts human beings by causing injury, etc., etc. That's expressly found here. And it's based on facts. So we'll come to that. Sorry. Yes, of course, of course. Yes.
When you talk about cruelty to animals,
Yeah.
to the human beings.
No, I'm not saying cruelty to human beings. I'm saying 21.
21.
Yes.
21 is defining, you said that.
Death and injury.
Death and injury.
Right,
Exactly.
right.
Death and injury. We are
Yes,
taking
yes,
it.
yes.
You take the case again, we go back to the example of a boxing match.
Yeah.
So the argument, when we put this to Luthra, his
Yeah.
argument was,
Right.
there's a distinction because in the case of a human being,
Yeah, he said there's agency.
agency, and he's consenting to it.
Yeah.
He's agreeing to it.
Yeah, all right.
He's agreeing to it.
Okay. fair.
So when the human beings who are dying,
Right.
obviously they are agreeing to it because they are agreeing to it.
No, I don't know about agreeing to it, but anyway,
That is the argument.
no, they are there for agency in the sense nobody's forced them to go and watch the Jallikattu. That's the point.
Exactly.
That's why I'm not saying no.
Look, if that is so.
Right.
Would you want this example, in the
Right.
extent that tomorrow we'll have to put an end to boxing match?
No, I'm not asking you to put an end to boxing at
Why
all.
not?
We'll just confine ourselves to Jallikattu. I have some little bit of understanding on that. So we'll try and help you there.
I'm not paying attention today. What I was saying is, take it to that level.
No, don't take it
That-
to that.
that-
No, don't take it to
You
that.
cannot.
You don't take it.
You can't have it.
No, you please dismiss my petition, but don't ban boxing. For whatever reason, we must confine ourselves as a constitution bench. The discipline of this court invariably is to decide on the narrowest possible
Exactly,
issues.
exactly.
And I think that's a system which we long followed, and I commend it to the court. So let's keep boxing for another day and another case, if it ever comes up. So,
But you have not answered my question.
no, I am not saying, I am saying that 21 peripherally arises in my submission. My primary submission, that's why I'm answering it threadbare. I am not saying that 21 front and center is the point I am going to canvass. I am not going to canvass it because I have said that I have retreated from the submission of personhood as far as bulls are concerned. If there's no personhood, there is no 21, at least as far as the bull is concerned. Then where is the 21? So 21 is in the context of spectators, and there is an element which you will find in this judgment and which was referred to. There's an element of humanism. That's a very important point. There's an element of compassion. That's a very important point. It's a duty and an obligation under our constitution. And in that context, probably 21 comes in, whether the person is injured or not. So these are dimensions which your lordships will be alive to. But I mean, you'll be alive to it. I don't want to put it any further than that. This is the broad background of what my submission. Yes, I'm sorry. All right. So then, may I just take you?
I was
Sorry.
just putting,
Yes, of course.
sometimes what happened,
Sorry.
there are 5 issues arising
Right.
subject.
Yeah.
And out of 5, I'm not satisfied on one of the issue.
Okay.
I'll give up and say my other successors who will join me, they'll take up the issue and answer your question. But the issue which I'm satisfied, I'll answer. But if submission was 21,
No, my
I-
submission, my submission is different. I heard Mr. Krishnan Venugopal, for example, say on the first day, he canvassed a position that this is in list 1. Now, I don't want to dilute that submission, but instead of fielding 10 questions from you on list 1 or list 2, I am making the concession straight away to save time. And I am saying, look, I'll please locate it in list 3 as far as entry 17 is concerned. So at least that is Mr. Venugopal's problem, not mine, as to how to persuade your lordships to that point. I mean, I'm just giving. Yeah. Yes, so but I agree with what Mr. Justice Rastogi has observed. Namely, I am trying to put forward my best case. And at least on my limited understanding, these are the points which I thought I may be able to persuade your lordships to.
Scenario for you. So
Sorry?
You're saying that take the worst case scenario.
Right.
Leave out 21, leave out personhood, leave out.
Yeah, narrow it. I'm narrowing it. Yeah, I'm narrowing it for my.
Within that narrow, you are
Right.
going to score the point that you.
Hopefully.
Okay.
Now, I'm going to read a few quick paragraphs. I mean, there are several paragraphs, but I want to read them. And please keep this in mind. It's a factual. Now, my lords, I'll just mention. The court, at least my understanding of your lordship's judgment, sitting in panels of constitution benches, is that where cases are decided, founded on facts, then it has a certain repercussion on what the legislature can do and cannot do. And equally, it has a repercussion on what this court can or cannot do when sitting in a larger combination. Just keep that in mind. Why am I emphasizing the factual determinations? The reason is that if it is some pure issue of law, it never is a pure issue of law in that sense. But if there's some statutory provision which is interpreted per incurium, someone didn't look at some statute which was there, some law was repealed and it was pronounced on, then subsequent benches sitting in larger combinations take a particular view. But where cases are determined on facts, I would try and urge your lordships is probably a narrower focus and compass insofar as revisiting the correctness of an earlier decision. I'm not suggesting you can't do it, but perhaps the yardstick which you will apply may be a little different. If you are satisfied that, look, the earlier court looked at the facts threadbare and decided on fact. So this is the background, all right? So, Manoj, please go to page 559 of the judgment. Now, I'll go quite quickly. I have a list here before me of the paragraphs which Mr. Luthra had cited. So, I'm going to try and avoid those, but there are a number of ones which we will like to. So, this is the first judgment. It is 2014 7 SCC 547. So, please go directly to 559.
Yeah.
Now, the opening paragraph itself, Lords, clearly frames the issue which arises here. We are in these cases concerned with an issue of seminal importance with regard to the rights of animals under our constitution, laws, culture, tradition, religion, and ethology, which we have to examine in connection with the conduct of Jallikattu, bullock cart races, etc. in Tamil Nadu and Maharashtra, more particularly with reference to so and so, so and so, so and so. Then it narrates these things, etc. Now, please see paragraph 3. This is a little important for my purpose because this is also an expression which Mr. Luthra had used. Look at para 3. ABWI, a statutory board established under Section 4 of the Prevention of Cruelty to Animals Act, for the promotion of animal welfare and for the purpose of protecting the animals from being subjected to unnecessary pain or suffering, has taken up a specific stand that Jallikattu, bullock cart races, etc., as such, conducted in the states of Tamil Nadu and Maharashtra, respectively, inherently violate the provisions of the PCA. So that was just a stand. We will be guided by the judicial determination. But my submission is going to be that after examining the facts, they came to the conclusion that this is inherently cruel, inherently brutal. Now, please skip the next several pages and kindly go straight away to page 562. Now, paragraph, just above paragraph 16. Bulls' behavioral ethology. Ethology, I discovered, is the science of animal behavior. Now, they look at the science of animal behavior. Para 16 is very important. Bulls so and so are herbivores by nature. Now, just see this. Adopted to protect them, adopted, I think it should be to protect themselves when threatened, engaging in a flight response. That is runaway stimulus when threatening. Bulls in the process use their horns, legs, brute force to protect themselves from threat or harm. Bulls are often considered to be herd animals. Bulls move in a relaxed manner if they are within a herd or even within the bull, with other bulls. Individual bulls exhibit immense anxiety if it is sorted away from the herd. Bulls vocalize when they are forced away from the rest of the herd, and vocalization is an indicator of stress. Bulls exhibit a fight or flight response when exposed to a perceived threat. Bulls are more likely to flee than fight, and in most cases, they fight when agitated. So the court actually looks at this later on as well. Now, please go straight away to paragraph 18 on page 563 about the fifth or the sixth, or I'll read the whole. Bulls, as already indicated, according to animal behavior studies, adopt fight or flight when they are frightened or threatened, and the instinctual response to a perceived threat is what is being exploited in Jallikattu or bullock cart races. During Jallikattu, many animals are observed to engage in a flight response as they try to run away from the arena when they experience fear or pain, but cannot do this since the area is completely enclosed. Jallikattu demonstrates a link between actions of humans and the fear, distress, and pain experienced by bulls. Studies indicate that rough or abusive handling of bulls compromises welfare, and for increasing bulls' fear often, now please note this, they are pushed, hit, prodded, abused, causing mental as well as physical harm. Then there is a full detailed description of Jallikattu in paragraphs 19, and paragraph 20 also goes into, now this is important, I'm going to only read some highlighted portion. So let me just indicate what is happening. In para 20 and 21 onwards, over the next several pages, there are detailed abstracts of fact finding on the basis of what the Animal Welfare Board of India found. I'm going to just highlight some of it. And let me just tell you, in anticipation of your Lordship's question, that we have, after the 2017 report, placed reports in this court, of which I will refer to the most recent one on affidavit, the 2022 report, where the same situation is continuing. Now, just see the executive summary, which begins over here. Now, I'm just, executive summary is the bottom of 563. Now, please go, so this is Animal Welfare Board, what they stated on affidavit in that case. Now, under 564, please go and see Roman 2, welfare implications and violations of the law. Ear cutting and mutilation. At least 80% of the bulls are observed had their ears cut with 3/4 of the external ear pinna absent. When asked about the reason for the mutilation, many bull owners explained that by cutting the ear, the animals would be able to hear sounds even from the back, when they, which were deemed to be very important when the animals are in a Jallikattu arena. Now, see the welfare concerns. Cutting the external ear in no way helps improve the bull's hearing. Instead, the bull loses its natural ability to receive sound signals with appropriate positioning and movement of the ear pinna. Cutting the ear causes intense pain and distress, as the external ear pinna consists of cartilage and is highly vascular with a rich nerve supply. The procedure leads to all sorts of, your Lordship will see, painful past experience. And then the violation is mentioned, which I'm going to skip. Look at 2, fracture and dislocation of tail bones. Many bones suffered from dislocated and even amputated tails caused by deliberate pulling and twisting. The welfare concerns are mentioned. The violation is mentioned. Please go to serial number 3 at page 565. Now, this is important. Frequent defecation and urination. 95% of the bulls were soiled with feces from below the base of their tails and across the majority of their hindquarters. Welfare concerns are mentioned. Please go to Roman 3. Then there's injuries and death under 4. Because of the absence of contained collation area in Avanipuram, a bull died after a head-on collision with a moving passenger bus, etc. Terrified bull sustained injuries, etc. Now, Roman 3. Cruel practices in violations of the law, biting a bull's tail. Now, just have a look. This continues. Then please see the bottom of page 566, last line. So that cutting of the tails, etc. There, look at the last. Using irritants. Irritant solutions were rubbed into the eyes and noses of the bulls inside the, I don't know how to pronounce this, vassal, in order to agitate them. And then the welfare concerns, etc. are mentioned. Please see plus item D on page 567. Pulling or twisting the nose rope exerts pressure on the nerve-rich and extremely sensitive septum, causing bulls pain and making it easier for the handlers to force them to move in the desired direction. According to one study, 47% of the animals whose noses were pierced had lacerations and ulcerations, and 56% had pus in their nostrils. The study also pointed out that 50% of the cattle had extensive and severe nose injuries. Now, Lords, this continues. Then there is a heading of bulls made to move sideways. That's at page 568. Lack of food and water is flagged by the Animal Welfare Board of India at serial number 8 on page 568. Then please see 9. Forcing bulls to drink liquids. On many occasions, bulls were forced to drink fluids and were likely liquor. Animals' heads were raised by pulling on the nose ropes, and the fluids were forced into their mouths using plastic bottles. The obvious welfare concerns are mentioned. Serial number 10, forcing bulls to stand in their own waste. Then spectators beating and agitating bulls is flagged at in para 11 on page 569. Now please see injuries and deaths, which is the main heading at page 570.
Before you
Yes, sorry. Yes.
It's important that we flag this.
Yes.
So these things apparently entered into the consideration of the court when it tried.
Yeah, absolutely.
Now, if all these things have been adequately redressed,
They haven't.
taken care of in the rules.
No, they're not. I've got my reports.
We are saying
Yes.
as to whether on the ground it's being done.
So let me just answer the question. Let me answer the question at two. First, in matters such as this, your lordships will see the effect of the law. You may have some great rule, but ultimately, if the material on the record before this court says that it has no effect. Second, and more important for my purposes, the 2009 Act, which is under challenge here, keep the issue alive, had detailed provisions and responsibilities on the collector, which is noted by this court. Which they set it out also, that the collector had to do X and had to do Y and had to look over here and look after that. Despite all those, 2009, when this case is rendered, decision is rendered in 2014, what your lordships has is breach, etc. Of these rules. So the point I'm making is twofold. I'm sorry. Yeah.
Difference is there.
Yeah.
That is why in the very beginning we put it to Siddharth also.
Yeah.
That we have to lay the 2009 Act and the safeguard there and
Yeah, we'll do that.
side by side.
Yes.
And find out if there is a complete change brought about, number one.
Yeah,
But as to whether on the ground,
Yeah.
these rules are being actually observed in the breach or in their observance,
Right.
it's a different matter. The impact we'll have to see.
No, but it has made no difference because it's being practiced. You see, there can't be a smoke screen over here. There ought not to be, at least, a smoke screen over here where you reenact the same thing. Instead of the collector, you have some couple of vets which go here and there or supposedly go over there. But on the ground, if the situation, just as you have the Animal Welfare Board reports, which are, look at the part which I have now, which I've reached just now at page 570, it goes district or town after town after town after town. I'm not going to read all those, but I'm going to just show you the headings. They found this across the board, across the state. And that's exactly the same thing which we have found after 2017, in 2018, in 2019, and in 2022, which is what I'm going to refer to. So there's no difference on the ground at all. So it's nothing but a smoke screen which is being put over here to try and say that, oh, now we've got a new law and therefore the whole everything is hunky-dory and don't worry, etc. about it. But ultimately, what we are going to hope to satisfy the court is, if it is inherently cruel, you see, the point is, if this activity is so inherently cruel, having regard to, going back to your lordship, the physiology or the body structure of the bulls, etc., what it's meant, it is important. I think that was an important question. Having regard to that, if the court has come to a conclusion that it is inherently cruel, then in our respectful submission, as far as the legislature is concerned, it cannot undo this at all. Because our separation of powers doctrine is very strong, that you cannot even deem it. You may earlier, before a judgment of this court, deem X to be Y and Y to be Z. But once there is a judgment of this court, our constitution bench has held, sorry, this is now the realm of the judiciary. We have made a determination. No question of the legislature saying that we are going to change. You can change the basis that your lordships are familiar with. But here what we are going to show is Jallikattu remains Jallikattu. The way it was practiced then continues to be practiced now. And because it is inherently brutal and cruel, as recognized by this judgment, we will urge your lordships to protect this judgment. And it's not as if it ends with this judgment. They had a full-fledged review. They had a hearing on review where they challenged the facts. This is very important. And this court rejected the reopening on facts by a detailed speaking order. So after that, what I'm going to suggest to the court is that the only recourse under our system, or at least under the architecture of the Constitution as we understand it, is probably a curative on these facts. on these facts in this. There may be other types of situations, etc. So anyway, let me not now just come back. So you have injuries and deaths. Your lordships will just see this was the question, the 21 aspect which the court is very alive to at the bottom of page 570. Jallikattu is dangerous not only for the bulls but also for humans. Many participants and spectators sustained serious injuries at all the 3 Jallikattu events. A total of 58 participants and 56 spectators were injured at the 3 Jallikattu events. 1 police constable was also injured at Avaniyapuram. Now, my lords, then there are conclusions, etc. Just see the conclusion. Now, this is in the earlier case at page 571. Bulls are prey animals. The animal behavioral studies, bulls adopt flight or fight response. This instinctual response to be perceived threat is deliberately exploited by Jallikattu organizers. During Jallikattu, many animals are observed to engage in the flight response as they run away from the people when they are experiencing pain or fear. The flight response is not surprising given the amount of pain and terror bulls are subjected to before and during the Jallikattu. Bulls are beaten, poked, prodded, harassed and jumped on by numerous people. They have their tails bitten and twisted and their eyes and noses filled with irritating chemicals. Many peer-reviewed papers demonstrate a link between the actions of humans and the fear, distress and pain experienced by animals. Research has shown that rough and abusive handling of animals compromises welfare by increasing the animal's fear of humans. Bulls who are pushed, hit, prodded, abused in Jallikattu suffer mentally as well as physically. Now, I won't read the rest of it, but just note, sorry.
That is not a conclusion by the court.
No, this is not. The consideration comes later. This is the factual basis. And now just see the heading, detailed reports of Jallikattu at so-and-so, so-and-so, so-and-so. So the next several pages I'm going to skip because these are same things found elsewhere at other locations, etc. Then please go to page 578. I'm not immediately concerned with this but the court focuses its attention on bullock cart races in Maharashtra, just above paragraph 25. Now, to answer just your lordship's question, judicial evaluation, where does that begin? Because your lordship is absolutely right. These were not findings by the court. Judicial evaluation begins at paragraph 33 on page 581, which paragraph 31, 32 and 33, right till 36, Mr. Luthra had read. So I'm not going to trouble your lordship. But this is just to point out, to answer your question, this is where the judicial evaluation really begins. With your permission, I'm skipping all the paragraphs all the way up to 37. And 37 then is cruelty to animals, and it sets out the various statutory provisions. Then there is a discussion regarding the doctrine of necessity. Then it goes to paragraph 43, which is performing animals. I'm going to skip that with your permission. And para 44, I think this may not have been read because at least my notes show that Mr. Luthra ended at 43. Just look at para 44 on page 586. Bulls, therefore, in our view, now this is a determination, in our view, cannot be performing animals, anatomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of 3 and 11(1) of the PCA. Now, just let me pause here for a moment. So, your lordship have the first sentence in para 40. So, this is independent reasoning to strike down the action, nothing to do with legislative competence or any of that, or as to whether there is a conflict with the central law. Bulls, therefore, in our view, cannot be performing animals, anatomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of section 3 and section 11(1) of the Prevention of Cruelty Act. Chapter 5, etc. deals with it. Now, please go, I'm just skipping again a set of paragraphs which were dealt with by,
Would the court have made the same observation?
Yeah.
If the amended provision of section.
Absolutely.
Because then there is no legally.
Sorry.
Legally, there cannot be a violation if the act doesn't apply. But therefore, in our view, cannot be performing, actually not, but are forced to inflicting pain in violation of section 3 and section 11.
That's the Parent Act.
That's Parent Act.
Yeah.
That Parent Act is now amended. We are
Yeah.
not considering the Parent Act.
Right.
I told you.
Right.
That if it were considering the Act, Parent Act, as amended by the Tamil Nadu Act.
Yeah.
The Tamil Nadu Act.
Right.
3(1) itself takes it out. 11(1),
Correct. So let me answer that. So the question is that suppose, so let's just look at the case a little differently. which is not what I commend the court to look at it, but we must look at it because let's look at it, examine it from every aspect. If this court were considering the 2017 Act itself, the question being put, or at least as I understand it, is 2017 Act. They're not looking at the 2009 Act at all. Then would this particular discussion and debate, etc., have come up? The answer is yes. And the answer is yes because we would have pointed out that, look, this is what the Animal Welfare Board says. These are the reports and the fact-finding on the ground. In this backdrop, this being inherently cruel, there's no question of a carve-out or an exception, such as is being sought to be done in the Parent Act by this amendment. So the question is, would the issue have arisen? The answer is yes, the issue would have arisen. So, Melod, sorry, if I understand it correct, let us drop the 2009 Act. Let us say that this very 2017 amendment came in the year 2009, an amendment directly to the Parent Act, not through this route of a state legislation. I think that's an important way of looking at it. My answer is, it would have met the same fate. Why do I say that? For all the very reasons, including the judicial determination. This is now I'm not on separation of power, etc. I am on the basic point that keep all those technicalities aside, this judgment ought to have or would have come down in our favor in any case. Why? Because the factual foundation was so powerful that this is the manner in which the 2017 Act is still resulting in abuse of cruelty, etc. And you cannot have an amendment in a law for prevention of cruelty to animals, which results or enables inherently cruel activity to continue. Inherently cruel activity. Yes.
We take that as your argument.
That is the argument.
And slightly, change the fact.
Yes, let's change the fact.
There is a challenge to the killing of animals for the purpose of preparing food.
Yes.
The answer is,
yes.
It is protected because even though it's a law dealing with cruelty to animals, prevention of cruelty to animals, Section 11(3)(e), to be specific, accepts out of the purview of the Act.
Yes, you're right.
Activities relating to preparing food of any animal.
Yes. With a caveat.
No, what you're saying is, killing the animal is the worst kind of cruelty you can do to it.
Now that jurisprudentially, now let me answer that. Jurisprudentially, both as far as human rights and animal rights is concerned, the approach globally is separate. To what? To killing or taking life, as your lordship correctly puts to me, and cruel. So, for example, in the Universal Declaration for Human Rights, nothing to do with animals, there is a separate clause on cruel and unusual treatment and a separate clause on right to life. Please keep that in mind. There's a distinction between. So, therefore, this court has held. Just now, I'm building on this point. There's a distinction between. So, the court gives you and upholds a death sentence all the way up to this court. So now it's over. Presidential saying all that is closed. Even so, there's an obligation. So your right to life is extinguished now. I mean, in the sense you don't have a legal right to continue because the highest court of the land has said that as affirmed.
Except in accordance with the procedure established by law.
Yes. So I'm not on that aspect. But what this court has held is that even after that stage, as far as treating a person inhumanly or cruelly, because we are drawing a distinction, your lordship is correctly putting to me that, look, if death is sanctioned, then where's the question of cruelty not being sanctioned in some, or not quite as crudely as I'm putting it, your lordships are far more subtle. But the point is that, look, if death is being sanctioned in some situations, then isn't cruel and brutal treatment something lesser? I am seeking to respond to that by saying that there are two separate judicial foundations or planks on which these arguments rest, both for human beings as well as animals. So now let me just complete that thought which I was putting across. So even after death sentences have been upheld, what this court has held is that it's cruel and inhuman treatment. If you keep a person on death row for 10 years, that's cruel and inhuman treatment. Please just imagine. He has no right to live under our system, etc., because it's been sanctioned. But you still cannot treat him cruelly or unusually. So not that the death warrant has to be executed in a particular manner and you can't use a cruel and unusual treatment while putting a person to death. That of course you can't do. But apart from that, You cannot, just because his right has been taken away or his right to continue to live has been extinguished through a process of law. So this is what even the United Nations, I mean, I mentioned it, the Universal Declaration of Rights. Equally, it applies to animals. This is now the second point. For animals also, as far as death is concerned, in terms of killing an animal, say for eating or whatever your other, there may be certain situations which have to be looked at distinctly, because as we will see from this judgment, the march of the law and humanism and compassion, which are constitutional values, etc., are such that when the animal is alive, you can't treat that particular person, the animal, in a cruel or unusual manner. I hope I made myself clear. There are two very, very distinct compartments. Obviously, Manoj, at a level, this is how I would suggest the law looks at it. Obviously, Manoj, in a casual conversation, taking someone's life is much worse than treating a person to cruel. I accept that.
No,
But, sorry.
sometimes, say, herbivorous animal is exposed to
Yes,
more violent and carnivorous animal in the forest.
you're right. That's a natural manner in which it
Yes,
plays out.
but
You're right.
sometimes they are engineered to be in that forest to be
Absolutely.
food of
Oh, absolutely.
carnivores.
Yeah. This act will not extend to such situations at all. Not at all.
No, this act directly would not. But suppose
It's a question of human compassion.
suppose man,
Oh, correct.
to an human agency,
Right.
these herbivores are put into a forest
Right.
to be consumed ultimately by carnivore.
Right. Right.
Now, would not that amount to cruelty?
Now look, let me just respond.
We are thinking extreme
Yeah.
because
So frankly, I haven't thought of it that deeply, but I think with these cheetahs arriving in Kuno, they may have to
we
some
are not
requirement to
we
prepare.
are not
some-
referring to
Yeah.
any.
Yeah, but there may be a necessity if a predator is being rehoused somewhere, or you may have a requirement to expand the prey base. Frankly, I haven't thought of, about introduction of prey to expand the prey base for a predator, whether that falls foul of this. But I'll reflect on it and I will respond to your lordship. But I don't think this has a direct application. I think the question is very pertinent on a larger philosophical level. But I think what we are dealing with here in this case is a very real
It
situation.
was an extreme situation, but
No, I agree with you.
not an unreal situation.
No, it's not an unreal situation. It may or may not. I will have to reflect on that as to whether it is this thing. But my preliminary response is that when the Prevention of Cruelty to Animals Act is at the intersection of human beings and animals. Yes. It's at the intersection of human beings and animals. It is not at the intersection of animals and animals. I mean, that's just in terms of an approach.
Sam, please
Yeah.
read
Yes.
this from
Yes,
Sam.
Sam, yeah. Yes.
You're talking juridically about legal rights.
Yeah.
How it has been viewed by the author and what.
Yeah, read it. I'll just read
Please
it.
read
Yes.
the portion which you have underlined.
Yes, I will. This is Manoj at page 40, this is page 219 of Salmon on Jurisprudence, and it's the 12th edition. It is to be noticed that in order that an interest should become the subject of a legal right, it must obtain not merely legal protection, but also legal recognition. The interests of beasts are to some extent protected by the law, inasmuch as cruelty to animals is a criminal offense. But beasts are not for this reason possessed of legal rights. The duty of humanity so enforced is not conceived by law as a duty towards beasts, but merely a duty in respect of them. He who ill treats a child violates a duty which he owes to the child and a right which is vested in him. But he who ill treats a dog breaks no vinculum juris between him and it, for there is no bond of legal obligation between them. Similarly, a man's interest may obtain legal protection as against himself, as when drunkenness or suicide is made a crime. But he has not for this reason a legal right against himself. The duty to refrain from drunkenness is not conceived by the law as a duty owing by a man to himself, but one which is owing by him to the community. And then further down the underlined portion is, there's nothing in the nature of things to prevent a legal system from regarding right as inhering in animals or idols. And in fact, some Eastern systems do regard rights as inhering in idols. Rights may also be bestowed by the law on artificial persons such as corporations. Yet in both these cases,
Next page also.
yes,
Next page also, legal, what are the requirements of a legal right?
Yes, the characterizations of legal. If every legal right has the 5 following characteristics. It's vested in a person who may be distinguished as the owner.
Therefore,
It avails against the
there's
person.
an owner of the right.
Yeah,
Because every
right.
legal right.
Yes, thank you for this.
Yeah.
Just remember.
Because we have to proceed.
Yeah.
When you're examining animal rights, when
Yeah.
you're saying, we're talking
Yeah.
about animal rights.
No, we're not
Talking
doing
about,
that.
talking about animal rights here.
No, I'm not talking, I'll come to that later. So far, I'm not talking about animal rights at all. I am.
Are you saying that animals don't have rights?
No, I am not. Because animals have rights in the form, they have, for my purposes, let me make it very, very clear. I am not suggesting for a moment that animals have constitutional rights on our present status and understanding of the law.
Legal rights.
As far as legal rights are concerned, as Nagaraj says, they are a mirror image of obligations of individuals and the state. So that's one element. That's the language used. There are rights and duties. There are, as the Nagaraj judgment says, there are duties cast, say, on the owner. There is a corresponding reflection that may be termed under certain jurisprudential principles as a right not to be treated cruelly. That's one. But I am not going that far. I am saying that the structure of the law as we understand it requires and imposes duties on individuals, and it imposes a duty on the state, which involves elements of compassion to animals, etc. In that context, you as the state has a constitutional obligation to ensure that it doesn't visit bulls with cruelty. So this is one part of the argument, but I must complete the second part.
You are not relying on para 66 of Nagaraja?
No, I am relying on 66.
Please read para 66 then.
Yes. 66 is the
rights guaranteed to animals under section 311, etc. are only.
Yes, so this rights guarantees. So just
how they could be elevated to the status of a fundamental rights, that was the consideration.
No, sorry, that's not how this judgment ought to be read. Now let me just answer it.
That's why para 66, that is the starting point. We just read that.
No, the starting point is before 66, but I'll read 66.
66, the way.
Rights guaranteed to animals under sections 3, 11, etc. are only statutory rights. The same have to be elevated to the status of fundamental rights, as has been done in a few countries around the world, so as to secure their honor and dignity. Rights and freedoms guaranteed to animals under sections 3 and 11 have to be read along with 51A(g) and H of the Constitution, which is the Magna Carta of animal rights. So now let me answer this question. Now, let me just complete the answer, and it's in answer to Justice Ravi Kumar. Yes, I'll just come to it. So there are two elements. Now, Milaj, we are just on this notion of animal rights. So I'm only on that for the moment, then I'll pick up the thread where we left it. As far as animal rights is concerned, they arise in two manners, two ways. The expression animal rights as used in this judgment and as understood globally is in two contexts. What are those two contexts? One, for our purposes, is a reflection of the duty cast on humans. That's one. So if there's a duty cast on humans, this court has interpreted it, the law, to be a corresponding right to animals to that limited extent. It's a limited right. The other are, what I indicated earlier, 5 freedoms which are held universally in the jurisprudence to be a foundation of compassion to animals. So one of the freedoms, for example, is that, and I'm just using an expression, thermal comfort. So you can't put an animal in something which is so cold that it is miserable all that. I'm just saying cold just now. You can't put equally an animal which is accustomed to a cold environment in something which is very, very hot. This is not a right which your lordships find in prevention of cruelty, but it's an act it's a right which is derived, and it is derived from the fact that this right to thermal comfort is one of the 5 freedoms which is recognized in the context of animals, particularly sentient animals, which are dealt with. So para 66 is very important. We are very much depending on 66, but it's in the context of the earlier paragraphs which I'm about to read. Then we will have a fuller and a more complete understanding. So, my lords, please see para 44 I read. Now just please go if your lordships would, to straight away, just have a look at paragraph 53. Now, this I'm not going to read because I believe, at least my notes show that Mr. Luthra read 53 as well as 54. But front and center, this court looked at culture and tradition. Because please see the statement and objects of the 2009 Act. The statement of objects of the 2009 Act refers to an ancient culture and tradition and does not state that it has any religious significance. Even the ancient culture and tradition do not support the conduct of Jallikattu or bullock cart race in the form in which they are being conducted at present, and it goes on. So these are factual determinations which are based on the basis of the material which is before them. Now please see, very important in answering this question, international approach to animal welfare, which begins at 590, page 590. So first they talk about the first stage, human self-interest reason for environmental protection. So they explain the various global treaties in the 17th, 18th century, etc. Then the second stage talks about international equity. This stage saw the extension of treaties beyond the requirements of the present generation, so also to meet future generations of human beings. This shift is signaled in a departure from the pure tenets of anthropocentrism. For example, then they talk about the Whaling Convention, etc. And then it goes to the third stage, nature's own rights. Recent multinational instruments have asserted the intrinsic value of nature. It refers to the UNEP Biodiversity Convention of 1992. It mentions several cases in paragraph 58. And then please have a look, if your lordships would, to paragraph 59. Based on ecocentric principles, rights of animals have been recognized in various countries. Protection of animals has been guaranteed by the Constitution of Germany by way of an amendment in 2002, when the words "and the animals" were added to the constitutional clauses that obliges the state to respect animal dignity. Therefore, the dignity of animals is constitutionally recognized in that country. German animal welfare law, especially Article 3, provides for far-reaching protection to animals, including inter alia from animal fights and other activities that may result in pain, suffering, and harm for the animals. Countries like Switzerland, Austria, Slovenia have enacted legislation to include animal welfare in their national constitutions so as to balance the animal owner's fundamental rights to property and the animal's interests in freedom from unnecessary suffering or pain, damage, and fear. Then there's a reference to the Animal Welfare Act of 2006 in the UK. With your permission, my lords, I'm going to skip that. And then please see para 62. The Universal Declaration of Animal Welfare, UDO, is a campaign led by the World Society for the Protection of Animals, WSPA, in an attempt to secure international recognition for the principles of animal welfare. UDO has considerable support from various countries, including India. So and so believes that we should look at the success of the Universal Declaration of Human Rights as set out that UDO can achieve for animals. 5 freedoms referred to in UDO, which we will deal with later in this judgment, find support in the Prevention of Cruelty Act and the rules framed thereunder to a great extent. So now this is the important part. Now see the next paragraph. World Health Organization, of which India is a member, acts as the international reference organization for animal health and animal welfare. OIE has been recognized as a reference organization for WTO, and in the year 2013, it had a total of 178 countries. On animal welfare, OIE says that animal is a good state of welfare if it is healthy, comfortable, well-nourished, etc., able to express innate behavior as it is not suffering from unpleasant states such as pain, fear, and distress. Chapter 7.1.2, Guidelines of OIE recognize 5 internationally recognized freedoms for animals such as 1. Freedom from hunger, thirst, and malnutrition. 2. Freedom from fear and distress. 3. Freedom from physical and thermal discomfort. 4. Freedom from pain, injury, and disease. And 5. Freedom from to express normal patterns of behavior. Food Agriculture Organization, in its legislative and regulatory options, etc., indicated that these 5 freedoms found their place in the Farm Welfare Council 2009 of UK and also called the Bramwell's 5 freedoms. These 5 freedoms, as already indicated, are considered to be the fundamental principles of animal welfare And we can say that these freedoms find place in sections 3 and 11 of the Prevention of Cruelty Act, and therefore animals like the rights guaranteed to citizens in this country under Part 3. So this is the context. Now I am mobilized for your Lordship's observation 66. Rights guaranteed. So in this context, your Lordships will see 5 freedoms, mirror, reflection and duty, 66. Rights guaranteed to the animals under 311, etc. are only statutory rights. The same have to be elevated to the status of fundamental rights, etc., as done by few countries. Rights and freedoms guaranteed to the animals under section 3 and 11 have to be read along with articles 51A, G and H of the Constitution, which is the Magna Carta of animal rights. Then it goes into the whole value of compassion, which is very important. It looks at humanism, which is a very important feature. Then I think I'm just seeing, yes, Mr. Luthra read paragraph 71. So I'm not reading para 71, but please see, now this is the right to life discussion at 72, and just have a look at para 73. Jallikattu and other forms of bull races, I'm on page 596, as the various reports indicate, cause considerable pain, stress. Now this is a determination by the court. This is not just some report. Cause considerable pain, stress and strain on the bulls. Bull in such events do not, not only do move their head, showing that they do not want to go to the arena, but as pain is inflicted in the varivassal is so much that they have no other go but to flee to a situation which is adverse to them. Bulls in that situation are stressed, exhausted, injured, and humiliated. Frustration of the bulls is noticeable in their vocalization. And looking at the facial expressions of the bulls, ethologists or an ordinary man can easily sense their suffering. Bulls otherwise are very peaceful animals dedicating their life for human use and requirement, but they are subjected to such an ordeal that not only inflicts serious suffering and injury to behave in ways, namely that they do not have, force them into the event which does not like, and in that process, they are being tortured to the hilt. Bulls cannot carry the so-called performance without being exhausted, injured, tortured, or humiliated. Bulls are also intentionally subjected to fear, injury, both mentally and physically, and put to unnecessary stress and strain for human pleasure and enjoyment, and that too, a species which is totally dedicated its life for human benefit. We are therefore of the view that sections 21 and 22 of the Prevention of Cruelty Act and the relevant provisions have to be understood in the light of the rights conferred on animals under section 3, read with sections 11(1)(a) and O and articles 51A, G and H of the Constitution. And if so read, in our view, bulls cannot be used as performing animals for Jallikattu and bullock cart race, since they are basically draft and pack animals, not anatomically designed for such performance. So this is the point. Now, repugnancy comes later on. So, on a foundational fact of what the court was fully and completely satisfied with, they found that this is inherently, Jallikattu is inherently cruel, a treatment being meted out to these bulls, and therefore it can't. Obviously, the next part I'm not required to read because it's on the repugnancy argument, and then the conclusions have already been read to your lordships. On this aspect, I'm just mentioning to the court, in 91.9, I started with that. Parliament, it is expected, would elevate the animals to that of constitutional rights as done by many other countries, etc. So I am not claiming that it is already there and lodged in the Constitution. Your Lordship will just give me. If you can. Now, that done, may I just take you to the judgment? If your Lordships, are you reading this from volume 5, Convenience Compilation, volume 5? Is that where your Lordship does the book?
We have
the book. Then please hand over 2017 to SEC, page 144. Now, let me indicate what happened. What happened was that a review petition was filed by none other than the state of Tamil Nadu, which is the correct constitutional recourse. The correct constitutional recourse is if you are dissatisfied and if you feel
144.
2017 to SEC 144. So this is a judgment rendered on November 16, 2016. Sorry?
This is 60 order.
No, I think this is Justice Deepak Mishra. and Justice Nariman. This is Justice Deepak Mishra. It reads as judgment, but I'm not sure as to who's authored it. But in any case, so let me just sum up what has happened over here and then I'll take you to the paragraphs. So a review was presented, which is the correct constitutional recourse. This is absolutely correct what the state of Tamil Nadu did. They came back to this court and said, you have made errors of fact. Please review the judgment. The court looks at it and rejects it. That's one. And number two, there are certain objections which are raised also on the law in the course of the review. So we have the advantage of a speaking judgment here. It's not just. So please see the judgment itself begins from page 146. It starts narrating that, look, ordinarily reviews are decided on circulation, etc. But here we are looking at it a little closer. And then just have a look at paragraph 2. Now, I might just mention, they exhaustively revisit the sections, etc. I'm not going to read them all, but I'll just read a few paras. So for adjudication of the review petition, certain facts need to be stated on 11th July 2021. So they mentioned, my lords, that performing an notification that, and which says that as far as bears, monkeys, tigers, panthers, lions and bulls are concerned, these are not to be used as performance animals. And then your lordships will see the conclusion in Nagaraj's case is set out in paragraph 4. With your permission, I'm going to skip that entirely. Then please go, if your lordships would, sorry.
25, actually.
I think I can go straight away to that. I want you to just see one other part, because I'm not going to take you to the sections. So just earlier, just have a look at paragraph 14. Paragraph 14 on page 151. Having scanned the anatomy of the PCA Act, now they looked at the PCA Act, then it's obligatory on our part to refer to the 2009 Act, as Mr. Nafde, learned senior counsel, would urge with emphasis that the purposes of the Act is to regulate Jallikattu in the state, etc. So then they show us the definition. Now look at this para 50. See, this is important because all the arrangements were already there. This is the point. Section 3 of the 2009 Act treats conducting Jallikattu as an event. Section 4 casts a responsibility on the organizers. Who organizes the event? Section 5 requires the collector of the district to make arrangements. Now, please see the arrangements which are made by the collector, which is under Section 5. Collector shall ensure double barricading, ensure number of spectators in the gallery shall not exceed the time limit, ensure safety certificate is obtained from the public works, ensure that the bulls are free from disease, nicotine, etc. Arrange to provide, not intoxicated, and administered with nicotine, cocaine, with the object of making some aggressive and ferocious behavior. Arrange to provide adequate police protection. Arrange to provide adequate medical facilities, which means a vet, ambulance, etc. Arrange that necessary drinking water as well as sanitation facilities in the place where the event is to be held. Authorize an officer not below the rank of deputy collector to look after each item in the event. An arrangement like checking up the bulls, checking up the bull tamers, checking up the barricading, arrangements, medical facilities, water supply, sanitary arrangements, safety of spectators, etc.
Oversimplifying.
Yes, sorry.
Unless you really, go into the details of the rules,
Right.
we may not be doing justice to the rules.
Which
It is
rule?
not about-
Present rules.
Yeah.
No, we'll come to the. I'm just on what was there.
This may not be, because this is primarily geared.
2009 Act
2009 Act.
and collector.
What you are
Correct.
reading
Correct.
relates to the safety of the spectators rather than on the.
No, the animals. I said that
The
nicotine.
rules now, it is slightly more different.
No. So let me just meet that argument. At least my understanding is, I think this clause here, ensure that the bulls are free of disease and not intoxicated or administered with any substance like nicotine, cocaine, with the object of making them aggressive or ferocious with the assistance of the animal husbandry department.
That is all. But in the rules, there are a completely different scenario is there.
Yes, sanitation facilities, drinking water, etc. I think this is the bull tamers. Look at the next one, Roman 8.
But
So look, I will just
see the rule.
we will see the rules. We will examine the rules. Okay, may I make a suggestion? My point over here is that if this had worked, if the rules or the Section 5 under the 2009 Act had worked, there is no question of any of the findings recorded in the principal judgment in Nagaraj being rendered. So basically what was happening was that despite the
Even if it had worked.
Even if it had worked.
Even if it had worked.
Yes.
It would still be.
All foul.
we found that it is still cruel to the bulls.
That's my argument.
That is correct.
I don't know.
But we're telling you.
Very well.
Take it as it is.
That's a step forward for me.
Take it
Yeah.
that it is correct from the court's point of view.
Yes, yes, yes. Right,
We're telling you after that when the rules were made,
right.
which is what the President Assent is all about.
Hmm.
It is not just Delicatu, which 311. It is also as a package 311 read with the rules, which is actually put in place.
So the act, the what received presidential assent is obviously the act, because that is all that receives presidential assent, and the rules are framed under the act. So we will come to that. We'll deal with that as well. But now just see the finding at page 153. So I accept at the moment that, look, this is in the context of the earlier set of law. You're absolutely right. Now, after in para 17, I won't read it, but they reproduce paragraph 73 and then see the plus item B just below the quoted portion on page 153. Thus, the contention that no cruelty is meted out to them while involving them in the event of Jallikattu does not commend acceptation. And it is extremely difficult to hold that the court in its judgment had factually erred. So this is now really, according to me, if we are right, this is the end as far as the state interference. Once there is a factual finding and the review is dismissed, then under Hurrah, you may be able to file a curative, but that hasn't happened yet. But that's the end of the road as far as the legislature is concerned as well. Why? As well, legislature as well. Why? Because there is a determination on facts. It has been found to be something which is unconscionable in the sense of cruelty and etc. to the animals and bulls. We're not going generally to animals on facts. So this is an important line just above paragraph 17. Then the hub of the matter, which is the act in consonance with. Now this is the other important aspect. The hub of the matter is whether such an act is in consonance with the prevention of. See, this is the test which will still apply. This will still apply even today. Not in the context of legislative competence. I'm not on that. I'm on the context of can you have these two at all standing? And in Nagaraj, the bench notes, they reproduce paragraphs 88, they reproduce paragraph 89. Now just see, go to page 154, second line from the top. Now this is a quote from Nagaraj. Overpowering the performing animal was never in the contemplation of the Prevention of Cruelty Act. And in fact, under section 3, a statutory duty has been cast on the person who is in charge of care of the animal to ensure the well-being of such animal and to prevent infliction on the animal of unnecessary pain and suffering. The PCA therefore casts not only duties on human beings, but also confers corresponding rights on animals. Now, this is exactly what Justice C.T. Ravi Kumar was putting to me. What is this nature of rights? Saman tells us that, look, as we have evolved as a system, we do not give personhood Saman. We do not give, this court of course may evolve it further. But at least as far as Saman's 12th edition is concerned, the nature of animal rights are not in the sense of a right vested in the animal, but a reflection of the duty to not be cruel. That is exactly what is cast here. The PCA therefore casts not only duties on human beings, but also confers corresponding rights on animals, which is being taken away by the state enactment by conferring rights on the organizers and bull tamers to conduct Jallikattu, which is inconsistent and in direct collision with section 3, so-and-so, which is the welfare legislation and hence constitutionally infirm. And then please see, the submissions of so-and-so is that there has been an inappropriate appreciation of the 2009 Act and the principle of repugnancy has been applied in a wholly fallacious manner. It is also put forth that the court has been influenced by international concepts of animal welfare and further erred in referring to the Upanishads, which should not have been referred to. Before adverting to the issue of repugnancy, we think we should deal with the submission that pertains to the reference to the Upanishads and international perception that is sought to be criticized. The court in Nagaraj, in paragraph 55, has translated a few lines from the Isha Upanishad, which reads as follows: the universe, along with its creatures, belongs to the land. No creature is superior to others. Human beings should not be above nature. Let no one species encroach upon the rights and privileges of other species. We do not think the allusion to the Isha Upanishad in the context of animal welfare is alien to the context. The court, we are inclined to think, while dealing with the law and legal principles, can refer to the cultural ethos and the ancient texts of the country insofar as they do not run counter to the constitutional and statutory thought and principle, as far as the international concept is concerned, etc., we are obliged to say that the philosophy of compassion can have manifold articulations, the last line. And then, my lords, it goes into the issue regarding repugnancy. Now, please go directly to page 156, para 26. Mr. Nafte Learned Senior Counsel has submitted that the 2009 falls under Schedule 7, Entry 2, List 14 and 15 of the Constitution. Entries 14 and 15 read as under. We really fail to fathom how Entry 14 can remotely can have anything to do with Jallikattu, which is an event solely because the event takes place after the harvest, etc. And then last two lines, thus we unhesitatingly hold that the activity Jallikattu falls squarely within Entry 17 of List 3, and therefore it has to be tested on the anvil of repugnancy, etc. And then the court goes on and rejects the review petitions, as your lordships have noticed. So now, my lords, where does this take us? Because we have a situation now where we have a full-fledged judgment, according to us, entirely on facts, and we are. Now, there is a useful decision which Mr. Luthra had referred to, except that he didn't read the paragraphs that I am seeking to rely on. There's guidance to be obtained. I'll state the point and then I'll come to the judgment. There is guidance to be obtained from this court's previous judgment, sitting in a constitutional bench strength, to the effect that where the court has examined an issue on facts, then the legislature has no role left at all. If it's on facts, I have to show, we've endeavored to show your lordships. I will deal with the present situation on facts in a moment. But let me just deal with this judgment, then I'll come straight away to the 2002 report, where to show that things haven't changed at all. Now, please just take up. Now, this judgment is in Mr. Luthra's compilation.
2014-12.
Serial number 31.
Is it 2014-12 SEC?
1412 SEC 696. Now, let me just indicate what happened here, and then I'll read the paragraph. So, this is State of Tamil Nadu versus Kerala. That's the caption. It's a constitution bench judgment of our court. In Mr. Luthra's list, if your lordship has that compilation, then it's at serial number 31. Otherwise, if you have the book, I'm more comfortable with the book. Now, let me just state the point. Here, there was a determination by the court with regard to what the height of Mullaperiyar Dam could be, should be, after a full contest, etc. And they came up with a certain figure. That was sought to be negatived through a legislative process. The court rejected this or struck this down on many bases. We are, of course, confining ourselves to this principle that if you have a determination made by the court on facts, then can it be reopened by the legislature? The answer we find over here is that you can't. Now, please, therefore, go straight away to the judgment begins at page 717. Your lordships have it. 717. Please go to paragraph 12 on page 719. 719.
You perhaps may not have to labor because it shows the paragraph. I think it's settled law.
Right? No, but I want to show some paragraphs which were not read to the court.
Family onwards.
Yes. Right.
I think it's fairly settled law. It's a matter.
Right.
Powers, the court cannot, the legislature cannot simply say, no, that's not the way it is like this. You are usurping the judicial power. Cannot be done.
So that's the general principle. Now I'm on something which is a little narrower. The narrower point which I am making is, it cannot be done on a case founded on facts. Because facts, those bills of attainder on which your lordships have in a panel of two judges reiterated, which I'll come to later on. But just let's see this. Paragraph 12 on page 719.
Actually, it was read to us, it is paragraph 149.
Yes, but I want to read a few other paragraphs. Your lordships have read 149. There's just a few. 114, yes. So yes. So, my lord, I want to read a few others.
Which paragraph you want to?
First, I want to read 12. 12. After hearing the parties, including the two states, so here again, Tamil Nadu and was certainly heard. After hearing the parties, including the two states, this court gave its decision on 27/2/2006, permitting the water level of Mullaperiyar Dam to be raised to 142 feet. The state of Kerala and its officers were also restrained from causing any obstruction to the above. It was also observed that after strengthening work was complete to the satisfaction of CWC, independent experts would examine the safety angle before the water level is permitted to be raised to 152 feet. Now go to paragraph 18, grounds of challenge to the 2006 Amendment Act. I'm just pointing it out. So the various grounds are set out, including the competence, etc. So I'm just pointing this out. I'm not going to read it, but your lordships have noted it. Now please go directly, if your lordships would, to paragraph 155. Yeah. On page 786, it is true that the safety of the dam is an aspect which can change from time to time in different circumstances. But then the circumstances have to be shown based on which it became necessary to make a departure from the earlier finding. It's always open for any party to approach the court in applying for reassessing the safety aspect, but absent the change in circumstances, factual determination in the earlier proceedings, even on questions such as safety of dam, binds the parties. If the circumstances have changed, which necessitates a relook on the aspect of safety, the court itself may exercise its discretion to reopen the case. But legislative abrogation of a judgment for even the very best of reasons and genuine concerns for public safety does not clothe the legislature to rescind the judgment of the court by a legislation. The contention of Mr. Salve that by declaring the dam unsafe, the legislature has not rendered any finding of fact. It deems the dam unsafe and sets up an authority to regulate it is noted to be rejected. What has been found as a fact by a judicial determination cannot be declared otherwise by applying legal fiction. We are, however, persuaded to accept the submission of Mr. Vinod Bobde, Learned Senior Counsel for Tamil Nadu, that the fact that the Mullaperiyar Dam is safe was found by this court, and that finding of fact can never be deemed to be imaginary by a legal fiction, which then proceeds to deem the opposite to be real, that is, the dam is in danger. This is not a matter of legislative policy, as it has been made out to be. Rather, in our opinion, it is an incursion in the judicial process and functions of judicial organ. The declaration under section 62A, read with item 1 of the second schedule, leaves no manner of doubt that the enactment is intended to reach the question decided by the court. The question whether or not a legislature has usurped the judicial power or enacted a law in breach of separation of powers principles would depend upon the facts of each case, considering the real effect of the law on a judgment or judicial proceeding. One of the tests for determining whether a judgment is nullified is to see whether the law and the judgment are inconsistent and irreconcilable, so that both cannot stand together. In that we have already discussed above, it is abundantly clear that on the one hand, there is a finding of fact determined by this court on hearing the parties on the basis of evidence and materials placed on the record in the judgment of this court in Mullaperiyar Environmental Protection Forum. And on the other hand is the 2006 Amendment Act. The Kerala legislature has declared the dam being endangered, and fixed the water level in the dam at 136 feet. If the judgment of this court in Mullaperiyar and the 2006 amendment were placed side by side, insofar as safety of the Mullaperiyar Dam as raising the water from 136 to 142 feet is concerned, it is obvious that the judgment of this court and the law enacted by the Kerala state legislature cannot stand together, and they are irreconcilable and inconsistent. The impugned law is a classic case of nullification of a judgment simpliciter. As in the judgment of this court, the questions of safety of the dam was determined on the basis of materials placed before it and not on an interpretation of an existing law, and there was no occasion for the legislature to amend the law by altering the basis on which the judgment was founded. When the impugned law is not a validation law, there's no question of the legislature removing the defect, as the judgment has not found any vice in the existing law and declared such law to be bad. There is yet another facet to the federal disputes. The legislature, parliament, and the state legislatures cannot be a judge in their own course in the case of any dispute with another state, the rule of law, etc. With your permission, I may skip that. And then please see paragraph 160. When a dispute between two states has already been adjudicated upon by this court, which is empowered to deal with the unilateral, which it is empowered to deal with any unilateral law enacted by one of the parties that results in overturning a final judgment is bad, not because it is affected by the principles of res judicata, but because it infringes on the doctrine of separation of powers, the rule of law, and as such law, the legislature has clearly usurped the judicial power. Now, this is very important. Once this court made a determination on facts on the basis of the material and the reports which was before it, then they came back And they said review because your findings of fact were wrong. This court rejected the review. Now, once that happens, no matter how egregious the decision of this court, from a legislative standpoint, you can't come in. There may be other methods of correcting the situation that I have mentioned to your lordships. There may be a curative system or other methods may be available under the, assuming it's wrong. I am of course saying it is entirely right. But certainly legislation, because this is the end of it. Once facts are determined as to the ethology of the bull, the physical nature of the bull, the cruelty inflicted on the bull, then by having a veterinary surgeon or something like that, and some distancing among spectators is not going to change the finding of fact at all. So the point here is, once you reach a determination, as this court has, that there is an inherent cruelty in Jallikattu, that is the end of the matter as far as the legislature is concerned. Otherwise, it is completely in violation of a very, very fundamental principle of our court. The next decision, I won't cite it. I mean, in the sense, I won't read it. I'll just invite your lordship's attention to it, and then I'll just get back to the facts for a moment. That decision, your lordship may note, is in re. Just give me that slide. Yes. No, your lordship may just note the judgment. So this case was followed by another constitution bench in the case titled Punjab Termination of Agreement Act 2004. In re, the citation is 2017 1 SCC 121. As I indicated, it is a constitution bench judgment. The relevant paragraphs are 33 to 37. And essentially what had happened there was that there was a decree of this court. There was a decree of this court, and it said that a certain canal has to be constructed, etc. That was sought to be negated by the Punjab legislature. The President of India made a reference to this court. The reference was answered, and relying upon state of Tamil Nadu versus state of Kerala, this court, again, you relied upon those paragraphs to come to the same conclusion that this is not the realm of the legislature at all. Once there's a judgment of this court, there's no question of undoing it. So I'm not citing it. I'm not playing. I've just given your lordship the citation.
What is the page?
Sorry. Oh, my mistake. Page is 2017 1 SCC page 121, and the relevant paragraphs are 33 to 37. 39. I'm sorry. My mistake. It's paras 33 to 39. Now, this is on this aspect. Now, I want to just go back. And here, this document is already in the compilation, but we're just going to hand it over because what has been done in the compilation, and I don't blame the persons who prepared it, was that they prepared black and white photographs. I am going to go on the text. We'll come to the photographs later. Now, there are a series of reports which we have placed on affidavit before this court. This is for the period 2017 and later. And we are first going to look at the text. This is all supported by affidavit. And then, give it to them. And then we will go to the whole issue regarding what is. So this is now bringing you up to date on facts. So this is now investigations into the Jallikattu events, 14th to 31st January 2022. Please go. You may cast an eye over the table of contents, but I'd be happy if you go to page 3. Please go to page 3. We will avoid all the photographs at this stage and go to the text. So please go to page 3. So we have now details of the investigation. So this is 2022, correct? January. Jallikattu events investigated. The places are shown. The districts are indicated. And the specific dates of the events are also shown. The objectives of the investigation are outlined: to record the treatment of bulls, to check for violations of animal protection laws and rules, and to record any reported human and bull injuries and casualties. Now look at the executive summary. PETA India's comprehensive investigation into 7 Jallikattu events, including 3 at so-and-so, Vellore, Tamil Nadu from 14th to 31st January 2022. Then the Prevention of Cruelty Act, which we mentioned the reference to the rules, etc. Not we. This report mentions it. Now please see the third paragraph. Furthermore, COVID-19 guidelines and restrictions issued by the Tamil Nadu state for Jallikattu were brazenly flouted. More than 300 participants were registered at some of the Jallikattu events, and more than 150 spectators were admitted at the so-and-so events, with the spectator galleries and the arena packed to full instead of 150 spectators or 50% of the state government protocol. The spectators weren't wearing any face masks, etc. With your permission, I'll skip that and go to the last paragraph. This latest eyewitness investigation, as well as the previous investigations of Jallikattu events, confirm that Jallikattu takes advantage of bulls' natural nervousness as prey animals, deliberately placing them in terrifying situations in which they are forced to run away from those they rightly perceive as a threat. The evidence of photographs and video footage shows that during Jallikattu events, bulls are hit, tackled, and poked with wooden sticks, including nail-studded ones, and other sharp objects. Their tails are bitten and twisted, and they are treated in other cruel ways. At the 4 events out of the 7 Jallikattu events investigated in 2022, exhausted and dehydrated animals were forced to participate after being made to stand in queues for several hours without overhead shelter or sufficient water or feed. They were yanked roughly by nose ropes, causing their nostrils to bleed, and many collapsed from exhaustion or dehydration from before and after they ran through the arena. Such abuse led to severe injuries, including broken bones and even death. The following statistics have been compiled based on multiple newspaper articles. In 2022, the number of deaths of both bulls and humans at the event skyrocketed within 4 months. Bull injuries and deaths are not always reported by the media, yet in 2022, between 13 January and 30th April alone, 1655 humans and 6 bulls were reportedly injured, and at least 17 humans and 2 bulls died. In 2021, between the first event in January and 25th April, 1,119 humans and 8 bulls were reportedly injured, and at least 14 humans and 1 bull died. In 2020, between January and 9th March 2020, at least 570 humans sustained injuries, and 13 humans and 6 bulls died during Jallikattu events. In 2019, at least 5 bulls and 1 cow reportedly died during Jallikattu events, and at least 8 humans reportedly died, and 597 people sustained injuries. In 2018, at least 6 bulls and 14 humans reportedly died. In 2017, at least 3 bulls and 20 humans reportedly died. According to news reports, the total number of human fatalities resulting from Jallikattu events in the last 7 years, from 2017 to 30th April 2022, is at least 86. In the same period, 6,351 humans were injured, and 23 bulls and a cow reportedly died. As Jallikattu continues, a staggering number of human deaths and injuries continue to occur. Over the years, even after the issuance of the Tamil Nadu PCA Conduct of Jallikattu Rules 2017, there have been a steady increase in reports of bulls' deaths, confirming that no amount of regulation can prevent participants from subjecting them to cruelty and injury. Inspections conducted by the Animal Welfare Board in 11, 12, 13, 14, and by PETA in 17, 18, 19, 20, and 21 have also demonstrated that Jallikattu is inherently cruel, causes bulls unnecessary suffering, and is a direct violation of the provisions of section so-and-so as held. Now, key observations and finding. Now, there is we'll skip the photographic evidence, so let's skip that. And from page 4, please directly first go to page 69. Leave one step. Go directly to 69. We'll deal with the photographs later on. No, actually, your lordships may go a little earlier, I think, to page 59. No? Please go to 59, 59.
We don't have any pagination.
Sorry?
There is no pagination.
At the foot.
Bottom.
Your lordships have bottom left.
Yes, correct.
So I just completed page 4. Now I'm requesting you to go to 59, 59. Now see what was observed. Onlookers and spectators at 7 Jallikattu events were filmed pouncing on and illegally tackling bulls fleeing in the bull run areas or arena. The same illegal practice was observed and filmed inside and outside the collection yards, where boisterous spectators jumped onto bulls and held onto their humps. This illegal practice was particularly rampant in the Jallikattu events at Avniyapuram, Palamedu, so-and-so. Parallel Jallikattu causes additional physical injuries and mental trauma to the frightened bulls. While PETA India does not support even registered participants tackling bulls in Jallikattu, illegal tackling by onlookers mocks the registered participants who undergo the compulsory protocol of registering, which includes undergoing a physical examination by a doctor, presenting a COVID-19 vaccination certificate indicating 2 doses and a negative RT-PCR test result taken 2 days before the event. While the participants were brought into the arena in batches and given a stipulated time frame to participate, several onlookers and spectators outside the collection yards illegally engaged in pouncing on and tackling the fleeing bulls throughout the duration of the event. Then please go to page 61, the page being at the foot. COVID-19 rules brazenly flouted. So with your permission, I'm going to skip that. Please see, your lordships may then go, just see the headings, please. On page 62, restrictions on number of participants violated. The other heading on page 62 is maximum spectator limit of 150 persons and 50% arena capacity rule violated. Then there was some no distancing, etc. Please go directly to page 73. Sorry? So, all right, 71, my mistake, 71. Yes, so I'm just going to read the headings. Actually, you may go one page back, page 70. Jallikattu events not held in open grounds. So this is some rule 2017 violated. We have given the full details over here in this report. On page 70, the organizers shall conduct Jallikattu in an open ground. Furthermore, GO says so-and-so, so-and-so. In Avaniyapuram, Jallikattu was held in the middle of the village in streets cordoned off by police and district administration authorities. So-and-so Jallikattu was held in the town center and its narrow bylanes. The arena erected by a bylane had a curved path, not a straight one, etc., etc. Bulls were observed and filmed skidding and falling to the ground in the so-and-so event, and so-and-so as a bull run area had a 90-degree turn. Then insufficient or no feed, drinking water or shelter. That's the heading at page 71, and the details are provided for in the text over there. Now, legal violations we have set out at, I won't be reading this, paragraph 73 onwards. I'm sorry, my mistake, page 73. Page 73, there's a heading on legal violations. So this is on the understanding that these rules are in force, etc. This is what the observers and those who prepared this report found. So open ground is violated. The caption says violations at the 3 events investigated. Then bulls shall be provided rest for a minimum of 20 minutes. This was not implemented at any of the events. Many bulls were brought the night before the event, forced to stand in a queue overnight, were made to wait for up to 16 hours. The whole idea, let me just tell you, what Justice Radhakrishnan found in the first judgment was that the idea is to enrage and provoke the animal. It is, and for that your lordship saw there's chili used in the nostrils, liquor in all sorts of orifices, etc., prodding, cruel treatment, and the animal is provoked, and then there is some sort of a contest on some understanding, I don't think cultural, but some machoism or something like that, and you try and mount on the bull and you hold him by the hump and whatever, you tame the bull. Tame the bull is a sort of a mild expression which I'm using. So there's physical violence and mental violence. What this report appears to suggest is, this is for 1 year, 2022. I'm obviously not going to burden, I mean, the court is already burdened in terms of the record with reports on 2018, 2019, 20 and 21. I won't be taking your lordships through those, but they are in a similar vein, where the activists, etc., actually went to the ground and examined for themselves as to what is happening. Now, so your lordships will have a look at this. Now, I'm just summarizing because I might just tell you that the photographs are extremely graphic, and the photographs are sometimes taken also from a feed. So, you know, obviously for a report, it's the best one which is captured, etc. So if you're seeing it in real time, you may not be able to really see the bull being whipped unless you really focus on it, etc. But let's keep that all aside. Let's go by the text. Please examine by the text. If your lordships have the time and the inclination, please also look at the photographs, because they cement our submission with regard to the cruel and unusual treatment which precedes this. This is not some sort of an entertainment where the bulls are being walked through a crowd or anything of that sort. Not at all. There's extreme provocation. So this is now the record and the state of the affairs insofar as what we are concerned with now. Now, my lords, I'm done with this report. I'm very grateful. Someone else may refer to the photographs in their time. Now, I want to just state the point, and I'm here departing from the practice of reading and presenting only constitution bench judgments of a strength of 5+, because we were not able to find this. So I'm just mentioning 2 paragraphs from a decision of a 2-judge bench judgment. It's got nothing to do with this case as such, but it's got a very important principle which may apply, on the bills of attainder. Now, this is a two-judge bench judgment reported at 2015 for SCC 400. And the relevant paragraphs are just paragraphs 13 and 14. I'll repeat the name. It goes under the title ST Sadiq versus State of Kerala, 2015 for SCC page 400. And this is not because this is in any manner binding, etc. But it's a historical peep into what used to happen and which now under the separation of law doctrine has been stopped and stymied in some places by constitutional provisions, as in the United States, as this court notes. So basically, there appears to be, at least on my understanding, a certain nature of acts of British Parliament called Bills of Attainder, where the Parliament itself would pass an act saying X or Y or Z is guilty. And the courts pushed back at that time and said that, look, this is ridiculous, in the sense they, of course, didn't have those powers. The courts there were also marking out their terrain. Then in the US Constitution, as this court notes, there was a specific constitutional provision that you can't have a factual determination and a judgment in an act. So if you just go straight away to page 411, I don't know whether those books have been placed to the, with the court. This is 2015 for SCC 400. Paragraphs are 13 and 14. Para 13 at the foot of page 411. It is settled law by a catena of decisions of this court that the legislature cannot directly annul a judgment of a court. Sorry. Oh, I'm so sorry.
See, we will read that, paragraph 13 and 14.
Yes, so don't, let's not burn. I will read it, it's not something, but it's interesting. It's settled law by a catena of decisions of this court that the legislature cannot directly annul a judgment of a court. The legislative function consists of making a law and not in declaring what the law shall be. If the legislature were at liberty to annul judgments of the court, the ghost of bills of attainder will revisit us to enable legislatures to pass legislative judgments on matters which are inter partes. Interestingly, in England, the last such bill of attainder was passing a legislative judgment against a man called Fenwick, was passed as far back as 1696. A century later, the US Constitution expressly outlawed bills of attainder. See Article 1, Section 9. It is for this reason that our Constitution permits the legislature to make laws retrospectively, which may alter the law as it stood where a decision was arrived at. It is this limited circumstance that a legislature may alter the very basis, etc. So anyway, I don't want to now repeat myself on the point that this was on a factual determination and you can't now by a judgment. What have they done, Manoj? I'm just asking. Why are we citing this decision or this concept of bill of attainder? What have they essentially done? What happened in Mulla Periyar? Basically, they said that, look, instead of 142, whatever, 132 feet is safe and anything above that is not. So they made a factual determination, a judgment, and appointed under a legislature, under a board to examine this issue of safety after it had been determined by this court. Now, what is happening over here? After this court has made a determination that this is cruel treatment inherently, Jallikattu and those races and those bullock cart races, having regard to the anatomy of the bull and the creature and its the manner in which, whatever, it's a sentient animal. So all of that. Having determined that, you now have a legislature saying, negating it by a bill of attainder or the equivalent, and saying that now we decide and say that as far as Jallikattu is concerned, the Supreme Court may have said this, it is not founded on cultural rights, but we say it is based on cultural rights. The Supreme Court has said that there is that there is cruelty inherent to this, but we say that there's a carve out and this is not covered under the Prevention of Cruelty Act. This is nothing but a bill of attainder in disguise. They have decided the issue, they have finalized the issue, and now they are, and this is a creep into the powers and authority of this court, which in our respectful submission ought not to be countenanced. So this is broadly the submission that we have. Now, let me just indicate the point, and then we will just give me that. Just give me a moment. Now, Manoj, sorry. Now I'm just on the next point that I wish to make. Now, what had happened over here, it arises actually in two contexts. and I'll just state them. This court was confronted with a situation, inter alia, where we had a decision, which your Lordship would recall, called Nas Foundation, which was rendered by the Delhi High Court. And basically, they just interpreted and declared the law that insofar as consensual sex between two adults is concerned, the statutory provisions, etc., would not apply. It was decriminalized. That was the extent of the judgment. That came up before this court, and we had a judgment which was rendered by this court in a case titled Kaushal. And the case and the Kaushal judgment essentially reversed the Delhi High Court judgment. That was a panel of 2 learned judges. Now, subsequently, the matter came to be examined by this court, sitting in a panel of 5 learned judges. Now, one of the arguments which was made was that when you have, for example, a constitutional court like the Delhi High Court rendering a final determinative judgment, and people are guided by that judgment, there is an expansion of rights. There's an expansion and an extension of rights in a manner of speaking, because the court has decriminalized something like. So therefore, human conduct in a society as vast and varied as ours also changes. People are accepting of that particular state of affairs, etc. Now, in this context, the argument which was advanced is that now, having moved this distance, it is no part of the duty of this court to retreat. No one suggested that this court is robbed of its appellate power. Not at all. Of course, this power, appellate power, continues. Jurisdictionally, the judgment can be reversed. There's no doubt about any of that. But in the context of human rights, and in our case, it's a little different. It's a case, there's an expansion of certain body of rights, duties, obligations. There's an articulation by the court based on principles under the directive principles of state policy, etc. In a situation such as that, there's a progression. When you progress, there's a global human rights. I'm not saying animal rights, not yet. But perhaps your lordships, we are commending this to the court. Perhaps you may consider it appropriate. So in the world of human rights jurisprudence, when the law moves forward, at least through the court process, it doesn't retreat. So our request is that this principle has been recognized by this court, which is what I'm going to place, the progressive realization of rights under this whole notion that our constitution is a living document and therefore our rights can expand, etc. And that is the citation which I'd like to place. So this judgment is a Constitution Bench judgment. It's reported at 2018, 10 SCC, page 1. Yes. And I'm just going to give you the paragraphs because I've given you the full background, so your lordship need not go into the facts. The title of the case is Navtej Singh Johar. We find this portion, there is a plurality of decisions. The one I am relying upon is paragraphs 201 and 202 from Chief Justice Deepak Mishra's judgment. I'll just read it. Para 201 onwards, the doctrine of progressive realization of rights as a natural corollary gives birth to the doctrine of non-retrogression. You can't go back now, having moved forward. As per this doctrine, there must not be a regression of rights. In a progressive and ever-improving society, there is no place for retreat. The society has to march ahead. The doctrine of non-retrogression sets forth that the state should not take measures or steps that deliberately lead to the retrogression on the enjoyment of rights, either under the Constitution or otherwise. The aforesaid two doctrines lead us to the irresistible conclusion that if we were to accept the law enunciated in Kaushal, which I mentioned, it would definitely tantamount to a retrograde step in the direction of the progressive interpretation of the Constitution and denial of progressive realization of rights. It is because of Suresh Kaushal's view gets wrongly embedded with the minuscule facet and assumes criminality on the bedrock of being guided by a sense of social morality. It discusses about health, which is no more a phobia, and is further moved by the popular morality while totally ignoring the concepts of privacy, individual choice, and orientation. Orientation, in certain senses, does get the neuro impulse to express while seeing the other gender That apart, swayed by data, Suresh Kaushal fails to appreciate that the sustenance of the fundamental rights does not require majoritarian sanction. Thus, the ruling becomes sensitively susceptible. This is how the court concludes. But I think this is an important principle, albeit in the sphere of human rights. We are not in that sphere here.
How would you quantify
Yes.
rights?
Quantify.
You're talking about progression.
Yes. Oh, very well. I will answer that. So when I talk about what I meant by progression of rights, I mean the expansion of rights. So let me give you the simplest example. First, we have derivative rights. So these are inarticulated rights. I'm sorry.
Somebody is riding a two-wheeler.
Yes.
The state imposes a duty to wear a helmet.
Yes.
Is it a progression of right or is it a
I think it is.
regression of right?
No, I think it's progressive.
No, because here it's a duty is cast.
Yes, it may be.
Unless you wear it, there would be a penalty.
Correct. But it is a progression because you are saving lives. It's a step and a measure in the interest of saving lives of the person. Sorry.
Expanding the right or by limiting power?
Well, I suppose, well, in my mind, I have complete clarity, but that may not be another person viewing the same fact situation which your lordship is putting to me. To me, in the example which your lordship gives, it is to preserve life, it's to preserve, prevent motor accidents or whatever, if there's a motor accident, protect lives.
Throughout the Western world, this anti-vax movement went on.
Yeah, that's a
Whether that's a progression of right or a...
So let me just answer progression of rights. Let me answer it.
Anyway, maybe in this case, you are not called upon.
No, but I think the question is important. Let me give you a contemporary example. And that is the 9-judge bench judgment of this court in the judgment titled Puttaswamy. In Puttaswamy, we had 30 years of judgments of the Supreme Court saying there is a right to privacy, which is embedded in Article 9. Your Lordship recall. Nevertheless, the Union government said there is no right to privacy and harked back to a 1950s judgment of a larger strength, etc. Therefore, it fell on this court in a panel of 9. Now, privacy is not mentioned. Privacy is a derived right. It's a progressive realization of rights. And that is how it was anchored on the basis of various rights. The Lordship said, well, it's a portable right. That it's in 21, but it's also in 19. It also moves to 14.
Normally 14, 19, 21.
Absolutely, 14, 19, 21. And there may be facets of privacy which even lie outside this triangle, etc. So, I will not take very long, but will your Lordships permit me to continue on whatever date the court considers?
Are your Lordships sitting tomorrow in the same bench?
Same.
Oh, very well.
There was some confusion in the listing.
Continue tomorrow. Same bench.
Oblige me. Yeah, that's it.